one, and even, I mean, think like a drive-by, you know, multiple.
Right. And good Wednesday morning from our Fox 9 streaming center for our gavel-to-gavel coverage of the Apple River stabbing, a case that has now taken 2 full years to work its way through the criminal justice system. I am Paul Bloom. Of course, we've now reached the sentencing phase after a St. Croix County jury found Nicolae Miu guilty of half a dozen reckless counts following a nearly 2-week trial that most of you probably were with us for in April. Now, I want to run through those verdicts for you now. Guilty, first-degree reckless homicide for the stabbing death of Stillwater teenager Isaac Schuman. Guilty, 4 counts, first-degree recklessly endangering safety for stabbing 4 others. These 4 survived their injuries. For one, A.J. Martin, top left corner of your screen there. Somewhat miraculously, as we learned, doctors had to revive him after the violent encounter on the popular Tubing River in western Wisconsin. The others hurt that day, Ryhley Mattison, as well as brothers Tony and Dante Carlson. And then one final guilty verdict, battery, Madison Coen. The jury finding Nicolae Miu through that first punch or blow, leading to the escalation of the conflict between a couple groups of tubers and the now 54-year-old. It is important to note as we await sentencing, there are no specific sentencing guidelines as we have here in Minnesota when we talk about Wisconsin. So going into today's hearing, we really do not know what Circuit Court Judge Michael Waterman will do. We know Miu is looking at decades in prison, in fact, upwards of 100 years behind bars. But again, it depends how Judge Waterman wants to sentence. Now, before we look too far ahead this morning, let's take a look back at how we got here.
Go! It doesn't matter. He's not even looking for little girls! Go!
It is the cell phone video that defined the case and divided the community.
They were attacking me from all directions, and I truly feared for my life.
It also sparked a debate over the limits of self-defense.
Nikolai was not in fear, he snapped.
And left everyone asking, what if Nicolae Miu had just walked away?
Judge, the defense calls Nick Miu.
Mr. Miu, please stand. Raise your right hand. The clerk will administer the oath.
In riveting testimony, the defendant took the stand at his April trial and continued to justify his actions and his fears.
I stood my ground. I stayed in place.
You never backed up 1 step, did you?
No.
You had your knife out and you were prepared to use it.
To defend myself.
But prosecutors exposed a series of lies Miu told authorities in the aftermath of the deadly encounter.
What do you think was happening at that time?
They were fighting me. They pointed the knife at me. Both boys pointed the knife at me.
It took the jury less than 7 hours.
Okay, please hand the verdict forms to the bailiff.
To reach unanimous verdicts on half a dozen charges. Guilty, first-degree reckless homicide for the death of Stillwater teenager Isaac Schuman. Guilty, 4 counts, first-degree recklessly endangering safety for those who survived their stab wounds.
Question, did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
And finally, guilty, battery for slugging Madison Coen, a flashpoint that ignited the escalating violence on the Apple River that hot July afternoon.
I feel that justice was served.
I spoke to a juror by phone afterwards. He asked to remain anonymous.
I mean, it's not like anybody had a fence behind him or were holding him there. He could have went, even if it was the wrong direction, he could have walked away.
On Wednesday, Judge Michael Waterman will sentence Miu for his actions that day. Not walking away, lying, and ultimately killing Schuman.
It's been 21 months we've been waiting for justice for Isaac Michael Schuman. And we got it today.
Miu faces decades behind bars, but with no sentencing guidelines in Wisconsin, Judge Waterman has full discretion.
In many ways, self-defense is a community standard, and it's very dependent upon which group of 12 people within the community you ask.
Miu's defense attorney, Aaron Nelson, hoping for some humanity for the now 54-year-old.
But we're talking about 30 seconds in this man's life that he didn't set this up. He didn't want to be in that spot. He didn't try to be in that spot. He was in that spot. He did the best that he could. He's now been convicted of a crime for what he did. But that 30 seconds shouldn't just mean he dies in prison. But I'm worried he might.
And let me bring you up to speed. We've hit 8:20 in the morning Central Time Zone. Sentencing scheduled to begin at 8:30, so we have about 10 minutes to go. Joining me this morning is Debbie Lang, a local attorney, Hallberg Criminal Defense here in the Twin Cities. Debbie's walked us through the trial at times, and she's here to join us to walk us through sentencing. And you heard there, let's start there. You're a defense attorney. You heard Aaron Nelson talk about some humanity, hoping the judge sees a man who lived an otherwise crime-free, quiet, even admirable life, a successful engineer, married, no trouble with the law, 30 seconds of his life, kills somebody, stabbings. What is your pitch?
Yeah, I think that approach is the right approach for the defense. It's certainly going to be attacked by the state. The 30 seconds of his actions took a life away from a teenager. And so that 30 seconds took a lifetime. And so I definitely think that the state is going to focus on the fact that that teenager is not going to be back. And that teenager could have had a full life in front of him. He was loved by his family and others. But for Nicolae, the defense must focus on his character, his age, his lack of criminal history, and the fact that this is completely out of what anyone expected from his character.
8-9 minutes away from sentencing. I'm just curious, you've been in that courtroom or in a courtroom with a defendant, a convicted defendant. Just take me the atmosphere, what's going on. Are you sitting with your client? Take me through just what this looks like in Hudson right now.
Yeah, absolutely. The defense attorneys are definitely sitting with their client right now. And oftentimes, you're not talking about the sentencing at this point. You have prepared your client, you have prepared your arguments, you are ready at this point. So instead of focusing on his nerves at this point, they may be talking about something completely unrelated right now, just to try to put him at ease.
And you think about today, as we do sentencing, it'll start at 8:30. We know the first hour is devoted to victim impacts. So think about Isaac Schuman's direct family members. I know the judge we're not going to hear from uncles and school teachers and friends. It's very specific to a victim of the crime. Of course, we're talking about a juvenile victim in Isaac, so mom, dad, stepdad, brother potentially. And then the victims of the stabbings. A.J. Martin could be a compelling victim impact statement today if he so chooses. But what's happening on the other side? I mean, these people have to sort of gird themselves to one, speak in front of the defendant, and two, perhaps ask for maximum sentences or full justice from Michael Waterman. What do you figure, on the human levels going through some of these folks who are getting ready to maybe give sort of the most important statement of their lives?
Yeah, generally victims will have statements that are written out, or at least bullet points, because it is an extremely emotional thing to in fact give these victim impact statements. Generally speaking, you're going to talk about what you went through initially, those feelings that you had, the feelings that your family and loved ones had, and then you're going to focus on the effects that it's had on you after the incident itself, and the fact that those effects may never go away. And so it's a very difficult statement for a victim to give. And there are some that choose not to give a statement at all. And so it will be interesting here if in fact all of the stabbing victims choose to provide a statement, or if they ask that a member of the county attorney's office read their statements for them because they just feel that they're unable to do so. All of those options are acceptable, and it's really a personal choice for each of them.
Tell me, Debbie, does the judge know what he's going to do already? Does he at least have a window of, or, a rough estimate of what he will sentence eventually? Does it matter what he hears today?
Yeah, as attorneys, we sure hope that they haven't made their mind up yet. The judge shouldn't make his mind up until he hears all of the arguments. I definitely think that the judge has thought about it, of course, and has an idea of where he may go. But a judge is going to stay objective. The judge is going to listen to arguments from both sides. The judge is going to listen to the impact statement from the victims. And the judge is going to listen to what Mr. Miu has to say as well. So I think there are many judges that have said, yes, I thought I was going to do something initially, and then after I heard the arguments, I changed that. And that's not something they usually say on the record. They generally tell us that afterwards.
And we, of course, saw Nicolae Miu testify, compelling, riveting testimony back in April. So he did share his story, obviously, within the context of being asked questions and reliving it. He didn't remember a lot. He had to make up for some lies, significant lies that he told authorities. Can he make a difference today? And in his Aaron Nelson and the defense team talk to him about what he can say, you know, perhaps protecting his rights going into a potential appeals. But, you know, there is this idea, like, you know, he never owned it in that moment afterwards, right? He tried to obfuscate, lie, make up stories. If he's fully frontal, truthful today, could that go a long way? And Judge Waterman coming down off of some of these massive numbers he's facing. He's facing massive numbers, upwards of 100 years. So does it matter what he says and the humanity of that moment of taking ownership of what took place that day?
It definitely does. In Wisconsin, the judge is required to consider 3 factors when sentencing. The judge has to consider the nature of the offense, the need for community protection, and the character of the defendant. And that's going to be critical here. That's the one that Nicolae Miu needs to hit on with his statement and with the character letters that were already submitted to the court. Because, Paul, you're right. In trial, he didn't accept responsibility. He still may not accept responsibility for what he was convicted of, but I would anticipate that he's going to accept responsibility for the fact that lives were changed and a life was taken at his hands. And I fully expect that he's going to speak about the remorse that he feels for those actions, although I don't foresee him saying, I agree, I was reckless.
Well, let me set the stage for what's going to happen. So at 8:30, the court will gavel in Hudson, Wisconsin. Judge Michael Waterman has been very punctual, so we certainly expect to see him at 8:30. Again, I think I mentioned already, 8:30 to 9:30, victim impact statements. 9:30, 10:30, he's given for the legal arguments, and then finally the sentencing phase, where presumably we would hear from Miu and get this sentence. So it's scheduled to go till noon, so 3.5 hours is what Waterman has given. And one thing I do want to mention, and we talked about this off camera, is Judge Waterman is not allowing the victim impact statements to be televised, to be on camera, to be recorded. Obviously, we spoke about just how difficult it is for these people to do this, so he's shutting off the camera. It's a little unusual given how open they had been all through the trial, but as you stay with us this morning, we won't be able to show you the victim impact statements. We have reporters in the courtroom, so we'll get word on who's giving impact statements, perhaps the nature of what they're saying, but we won't be able to show that to you. But we have several hours to come. You'll be with us all morning as we get to that. And before we take a look in the courthouse, as our feed just isn't quite up yet, I do want to play one of the things is this jury found in the end was they didn't convict on the highest counts, the intentional homicides, the intentional stabbings. They convicted on a reckless level. And I spoke to some jurors in the aftermath. I have that story ready to go. So why don't we, again, to get our viewers caught up, let's go back and take a look at some of my reporting, the jurors' sentiments after their verdicts.
I was fearing for my life.
In many ways, Nicolae Miu's trial came down to witness credibility.
What the hell is this guy's problem, bro?
And the nearly 3.5-minute cell phone video of the escalating encounter.
If there was no video, how hard would that have made your job? What would that case have looked like?
It would have made the jurors' job very hard. I'm so thankful that we had a video to kind of base our thoughts on it.
Fox 9 spoke to a pair of jurors after the panel of 12, 6 men and 6 women, found Miu guilty on half a dozen charges, including first-degree reckless homicide.
I feel that justice was served.
The jurors asked us to conceal their identities, wishing to remain anonymous while taking us inside the deliberation process. I spoke to one over the phone who concluded Miu could have avoided the whole thing.
I mean, it's not like anybody had a fence behind him. They were holding him there. He could have went, even if it was the wrong direction, he could have walked away.
We felt like we put on a good defense, but in many ways, self-defense is a community standard, and it's very dependent upon which group of 12 people within the community you ask.
Or he could have walked right past everybody and went back to his group.
Both jurors reasoned if Miu threw the first punch, as several witnesses testified, he could not then claim self-defense.
You went to Mr. Miu, correct?
Yeah, I went to the guy who was punching people first.
Correct. Again, based upon your memory that he pulled someone's hair and punched them from behind, correct?
Based on the memory that I know that he punched someone, yes,
Okay.
It doesn't matter how he punched them. I know he punched them, and he shouldn't have.
Prosecutors included a charge of battery, arguing Miu struck Madison Coen first, sparking the physical altercation.
Why was it important to start your kind of deliberations or conversations around the battery?
The Madison Coen battery charge was a really big thing for the whole case because what that basically amounted to is, who threw the first punch?
While there was little support in the room for Miu's claim of self-defense, I am told that 2 or 3 jurors pushed for a conviction on the intentional homicide charges.
But after looking at everything overall, I think it was just more of a freak thing. It was people in the moment. I don't think initially he had the thought of, I'm going to kill one of these boys or all these boys.
Do you think he hurt or helped his case by going on the stand?
I don't think he had much choice but to go on the stand. I think if he really was going to plead self-defense and have a case, I think he needed to take the stand to explain himself.
I lied about the knife.
Was that your knife?
Yes, it is. It was.
In this case, which I think is probably with a lot of cases, it actually hurt him. Just like I am saying, because the stories did not match. There were so many things that were not true that he said.
And back out here live with Debbie Lang, our local criminal defense attorney here in town, legal analyst, to help us walk through the sentencing phase today. Debbie, we talk about reckless charges. He was initially charged intentional, which would have been a mandatory life sentence, so he got spared from that fate. But he's still looking at decades in prison. Can you walk us through a little bit of some of the, the windows on sentencing, the length of time in Wisconsin on these specific counts? Yeah,
and Wisconsin is different than Minnesota. So in Wisconsin, for the top count, the first-degree reckless homicide, there is a maximum 60-year sentence. However, the court in Wisconsin is required to bifurcate, which means the court is required to pronounce a specific amount of confinement followed by what's called extended release. People would think of that like parole or probation. And with that 60-year maximum, the judge cannot order 60 years of confinement. The judge has a maximum of up to 40 years of confinement, then 20 years of extended release thereafter. And if the judge were to go lower than that, for example, 30 years confinement, the judge could then do 30 years of the supervised release. With the battery counts, with the reckless endangerment of safety, that has a 12.5-year maximum. Again, have to break that down. The judge can go up to 7.5 years of confinement and 5 years of extended supervised release.
And then there are these 5-year escalators, because the jury was asked, did those crimes occur with a dangerous weapon? I mean, that would seem to be a no-brainer. It's almost should be part of the definition of the crime itself, but there is even an escalator on top of that where the jury did say and answered in the affirmative when they read their charges back in April, guilty of reckless homicide, dangerous weapon, guilty of first-degree endangering, recklessly endangering safety.
Well, we should also note that there is also that misdemeanor charge there as well, and that can carry with it a maximum of up to 9 months in the local jail. It's not a prison sentence because it's not a felony level offense.
And would you expect Michael Waterman, the judge here, circuit court judge in Wisconsin, to really lay out why he's doing it when he's presents the sentencing? Would you expect sort of a rationale, an explanation of what he does?
I definitely would. And a large part of that is I would think he would do that for the victims so that they are aware that this is a sentence that's being proclaimed because of what happened to you specifically. So I would definitely foresee the judge explaining why he's giving his sentence and giving sentences, of course, for each of those offenses very clearly so that each of those victims feel that they've been heard.
How would this case be taught in law school in the way consecutive versus concurrent? It is one incident, but there are most definitely, 6 victims, most severe obviously being Isaac Schuman, but then down the list there are 2 people who were significantly suffered significant stab wounds, 2 others, more, lighter pokes kind of thing, more superficial injury, and then of course Madison Coen, who's pit slug punched. Will the judge, would you be taught to sentence each individually and then put that on top and make you serve, kind of stack them all on top of one another, or is it to be done concurrent, like kind of all one incident?
Yeah, so the judge is going to have discretion. The judge could decide to sentence the matter concurrently, which means that all of the sentences run together. Essentially, the largest sentence would be the umbrella that encompasses all of the lower or lesser sentences. I wouldn't foresee that here. I think the judge is going to sentence consecutively. So that means you serve one sentence for one victim, then the next starts, then the next. And so essentially that's stacking them on top of each other. And for your viewers, you would then add up all the numbers to determine how long is he going to be in prison.
Let's take a moment here. We've hit 8:35. We still don't see our feed up from the courthouse. Sentencing scheduled to begin at 8:30. I'm just going to speculate a little bit. I'm not necessarily hearing anything from our booth on it, but there is the chance that they've gotten started late for some reason, that there's some issues on the ground there. We haven't heard that. There's also the possibility that they're not allowing the camera to come up initially because, as I mentioned off the top, the victim impact statements are not going to be allowed to be on camera. So perhaps the judge wants to just get through that portion and we just haven't seen the camera up. So I'm not sure what we're talking about on that front just yet. I do want to mention a couple notes that we picked up on just from the public court filings. I did note that the defendant, Nicolae Miu, his legal team had asked if he could show up today in street clothes, civilian clothes. The state fought him on that. They said, no, do the standard orange jumpsuit, handcuffs. Of course, there's no jury, right? You don't bring an inmate in that case because you could sway the jury or they could see something in his dress. But it does appear from the filing the judge rejected that claim. So we will see Nicolae Miu in jailhouse jumpsuit, while at the trial we saw him even though he was in custody and has been in custody now for 2 years.
And that's very common because the judge knows that he's been convicted and the judge is the one who's making the decision today, not a jury. So his attire isn't going to sway the judge one way or the other. And just practically speaking, getting those civilian clothes in to someone who is sitting in custody, having them change in and out, it causes more work for the jail. So I'm not surprised at all that the judge rejected that request.
And can we read into anything that it's kind of it's a slap at the defendant's request for some humanity or respect on this day?
No, I would say don't. Again, and it's because the judge, and I would have concerns if a judge was in fact swayed by what someone was wearing. Yeah. And so this is the judge saying, I'm going to be objective, I'm going to listen, I'm going to be fair. It doesn't matter what you're wearing.
We also saw that the defense has submitted its legal arguments. We talked off camera about what you think Aaron Nelson and his team might do today, because they know there is a high likelihood of a prison commit coming and a high number. So how do they spin their arguments? I mean, could they, in theory, show up today and, hey, he's 54, this was not anything of his doing, let's talk probation here? I mean, could we start it at that level, or do you have to acknowledge he's going to prison and maybe suggest a 10-year sentence with lots of community service on the back end?
I think they have to ask for probation based upon his attorney's statements and the clip that we saw. He recognizes that there is a lengthy prison sentence that his client's looking at. But I definitely think the defense can ask for that, but they can also then say, in the alternative, judge, let's cap it at, for example, as you said, 10 years. So it wouldn't surprise me at all if they ask for probation. Realistically, I don't think that they would bet their house on that. I think they know that their client likely is going to prison here, or someone lost their life, there are multiple victims. So I think they know that it's going to happen, but they have to ask. And, I would ask if it were myself. This is a gentleman with no history, his age, his family, his ties to the community, all of those components are important. And we're going to hear, I anticipate, remorse from him today. So talking about that remorse is going to be a focal point for them.
I want to ask you what the state will ask for. Will it be an automatic? Will the district attorney say this is a maximum case, sentence him to the top charge, top number on each count? But before I get your answer, I do want to let our viewers know that court has in fact begun in Hudson, Wisconsin, as we sort of suspected, and the camera is down because they have begun victim impact statements. And the very first impact statement is from Alina Hernandez, that's Isaac Schuman's mother. She had that heart-wrenching testimony, getting that phone call. She's out at a restaurant in Stillwater when she got a phone call from one of the boys tubing with Isaac that day that Isaac's been stabbed. It's about a 10-15 minute drive. She rushed to the riverbank, went into the wrong ambulance. It was just, she's crying on the witness stand, but everything she went through. I know she, once upon a time, was a single mom raising her 2 boys alone, really proud of where Isaac was in life. 17-year-old, started his own business. I mean, she's going to have a lot to say. I think it's a shame that they're not allowing victim impact statements because, you know, so especially Isaac. We haven't, outside of some news coverage, we haven't really gotten to know the young man. And today I know his family is going to provide that picture. So Alina Hernandez now giving her victim impact statement. It's about 8:40 now, so we're presumably about 10 minutes into this proceeding. So we're going to assume then the camera just never came up from the courtroom. I promise you we will get you out there just as soon as it does. Again, Judge Waterman not allowing victim impact statements to be recorded, to be videotaped. We have reporters in the courtroom, so we'll be able to get kind of the context of what these families say. But Isaac's mom certainly, you know, that's a tough one to sit through, to watch, to listen, and a very difficult day for her. And this is 2 years now. This happened July 30th, 2022, so we're 2 years on. And I know the case got slowed down for various reasons, but 2 years she's lived with kind of, now's her moment, and she's obviously delivering her impact statement at this point. With that, I want to get back to that question I had. The state's asked today. You gave the numbers, they're high, the 60 years, 40 confined, 20 out. Will they go for that? Do they have to acknowledge no criminal history, that type of stuff? Or do you see the state just saying, throw the book at him, send him away?
I think they're going to go big. I think they're going to ask, and they're going to focus on his age. And they're going to focus on the fact that, you know, just as the defendant didn't have a criminal history, neither did Isaac. This isn't a young man who, you know, when we watch the video, he wasn't as involved as some of the other young men in terms of yelling. And so I definitely think the state's going to come in and say this was such a young life that was taken, and taken needlessly. And so I think they're going to come in and ask for the 40-20.
You've compiled some stats. You did some reporting for me, and I appreciate it. As it relates to the first-degree reckless homicide conviction, are you in a position to kind of relay some of those numbers? It's really fascinating in terms of the number of convictions in Wisconsin under that top count. Now, this is very specific to the top count, right? We won't know what other charges unfolded with the homicide, right? Like in this case where we have other victims. But you have some stats. You want to kind of go through some of these numbers that I think our viewers would appreciate?
Yeah, it's interesting. So in Wisconsin, as well as Minnesota, you can request data regarding sentences that have been imposed for similar charges. And it's a very helpful tool for defense attorneys because you're able to look at historically, if someone is convicted of this offense, what sentence did they receive? You can also then look at their case, so the complaint, the charging document in the case, the indictment, to determine, all right, how are those facts different or similar from my case? And then you try to distinguish. And so here, you know, I know statewide in Wisconsin, since 2003, there were just shy of 1,100 charges of first-degree reckless homicide or second-degree murder. The stats compile those together. And so it's 1,094 specifically. And 8 of those cases happened in St. Croix County, so the county that we're dealing with here for this case. Of that, 713 of that 1,094, they were sentenced. So those people either pled guilty or were found guilty. The remaining matters either pled to a lower offense, had the case dismissed outright, or they were found not guilty. And of that 713, Paul, 711 of them were sent to prison. So that means only 2 received probation. So when I indicate that defense counsel should ask for probation, again, realistically, they know these numbers. These are great defense attorneys. They've done their homework. So they know that only 2 out of 713 convicted of this offense have received probation. So the likelihood's very, very low. Additionally, when you shake that out, we know that 695 of that 711 received a sentence of 10 years or greater. And so the statistics don't break it down to 20 years or more, it's the 10. But we know that 695 out of 711 received more than 10 years of prison. So realistically, those defense attorneys know, and the state also could have done this research and could get that information to say, Judge, probation isn't something you should consider.
And, you know, again, differences between Minnesota and Wisconsin in sentencing, the sentencing guidelines, but it's almost in the statistics create the guideline here,
Right, and yeah, Minnesota's guidelines are much more strict in terms of they tell the judge here's a very tight range, and that's based solely upon the criminal history of the defendant and the severity of the charge. In Wisconsin, the judge has greater discretion. They're not tied to that small box, that small window of numbers. In Minnesota, a judge can go above or below based upon what are called departing factors. But here, Judge Waterman has that complete discretion, so I would anticipate that attorneys for both sides are going to be looking at these numbers and asking the judge, to consider it. Here, we also know that Judge Waterman has not imposed a sentence for this offense since 2003. So we don't have historical data based upon what this judge is likely to do.
Yeah, so that's interesting. So Michael Waterman has never had a defendant in front of him convicted of first-degree reckless homicide, so this is new to him. And what's interesting, I do think about is he has a jury, and you heard Aaron Nelson in one of the sound bites in my earlier story, kind of right if you joined us about a half hour ago, talk about self-defense being a community standard. So these 12 jurors found, did not believe his claim of self-defense. Judge Waterman, he may have his own personal opinions here, correct, of what he sees in that video or what happened that day, but he has to sentence based on what this jury found.
Right. Even if Judge Waterman felt that legally self-defense applied and he should have been found not guilty because of that, Judge Waterman cannot let that come into play and into his mind when sentencing, because the jury has spoken. The jury has found him guilty. The jury found that self-defense did not apply. So at this point, Judge Waterman has to focus on those 3 factors when sentencing, and that doesn't include whether or not he thinks the jury got it right.
Mm-hmm. Debbie, it's been 4 months since the verdict. I know one of the phases of this time period is what's known as a pre-sentence investigation, where they speak to Miu, they dig into his background, everything. Could you enlighten us a little bit on what might be in that report, and how does probation make a suggestion on a sentence, and Judge Waterman might reference it today in court? What's in that pre-sentence investigation that we'll hear about and certainly has been filed? It's not a public document. It's filed, but we know it was filed a few weeks ago in advance of the sentencing today.
Yep, and it's not public because it has so much personal information about the defendant. I always explain that a PSI, or a pre-sentence investigation report, it's a book report about you. And so it takes and looks at the defendant from the beginning of their life all the way through. So it talks about their family, it talks about where they grew up, their education, their history in terms of employment. It will talk about military service. It will address potential issues, so it will focus on chemical dependency issues, gambling issues, mental health issues, physical issues. It truly is a comprehensive report about the defendant, and it's designed to give the judge an objective look at the defendant versus what is being said by his attorneys as well as the state. So here, probation is supposed to gather the facts. They generally would speak with other individuals as well to verify the validity of what the defendant is telling them. It, of course, includes criminal history. So not only if someone has been convicted of something, but if they have previously been charged with an offense. And it can even include traffic offenses, one's driving record. It truly encompasses everything. And then there's also, probation generally will reach out and ask the victims if they wish to provide any statements to the PSI writer. Here, I would expect that they would indicate that the victims plan on speaking at the sentencing versus submitting in writing through the PSI. And then generally, yes, probation does make a recommendation, but there have been times that probation merely states, here's what the law says. Here's what can be imposed, judge. These are the maximums. It's up to you.
Yeah, and there's 4 months that typically, that it seems a little longer. I'm usually maybe a couple months, but we've stretched out 4 months. I know it's a significant case, perhaps just part of scheduling as well.
Yeah, I would think it's because of scheduling. Generally speaking, about 8 weeks is sufficient for that PSI to occur. And here the defendant remained in custody, so it does make it a little bit easier because probation knows where he's at and they can contact him and meet with him when it's convenient for them versus trying to schedule with someone who's out of custody. But 4 months doesn't shock me, especially given the severity of this offense and, again, the likelihood of significant jail time. If this were a misdemeanor offense, different story. if the individual is sitting in custody, because you don't want to exceed that maximum, and defense would be asking for less.
And just again, I would reiterate all through the the trial back in April when you guys were with us before was we talked about if he's convicted on the intentional homicide, it's life in prison, he's got to avoid that. He did, but in all reality, with the numbers that he's facing today, Nicolae Miu, he very much, this could be in essence a life sentence for the 54-year-old. I do want to reset the situation right now. So we're coming up on 8:50. Sentencing began roughly at 8:30. The cameras have not come on in the courtroom, and that is because Circuit Court Judge Michael Waterman is not allowing victim impact statements to be recorded, shown on television. Obviously, the courtroom is open. We have a crew, maybe even 2 reporters in the courtroom today, but we can't bring the victim impact statements to you live. So I'm here with Debbie Lang, local criminal defense attorney with Hallberg Criminal Defense, kind of walking us through the sentencing. And as we regroup, I think what we could do now for our viewers is we have the cell phone video, right? The 3-minute, 20-second cell phone video that was so critical in this case. It really defined the case.
It was the piece of evidence.
Yeah, absolutely. And it in a lot of ways divided the community, because seeing it, depending on which section you look at, if you don't take it in its totality, you may come to one conclusion. Clearly, the jury came to another. You heard in my story a little bit ago, jurors never really, this group of 12 never went to the self-defense, so they clearly saw something in this video. So let's bring that up. That's Jawan Cockfield. That's a buddy of Isaac Schuman. He's tubing with him in the river that day. He's shooting on his cell phone camera. 3 minutes, 20 seconds. Let's go back, take a watch at that, and we'll come back with Debbie and see where we are from the courthouse in Hudson.
What is he on? Whoa! 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 Where's your way? Oh, God! We up! We up! What are you talking about? What the hell are you talking about? Get away from us! What? What's going on with y'all homie? He's on camera. Scripting. He's on 4K. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Go! It doesn't matter. He said he was looking for a little girl! He said he was looking for a little girl! You're looking for a little girl? Yeah! That's exactly what he said! Weirding us out! I didn't have that part on camera, did I? Some young-ass kid! What the hell is this guy's problem, bro? We're trying to have fun. He's gonna claim you. He's gonna claim you. We don't want this motherfucker. Get on camera. Get on camera. Oh God, he on camera. Oh God, he on camera. He ain't a woman! He ain't a woman! You ain't a woman! He ain't a woman! You got him! He's dying, bro! What? Oh my God! Oh my God! Oh my God! Oh my God! Are we serious? Is this real? Oh my God! Who is that? Oh my God! Oh my God! Is this real? Is this real? Oh my God! Oh my God! What the fuck? Is this real? Wait, that's not Bike! That's not Bike! That's not Bike! That's not Bike! That's not Isaac! Oh my God! my God! This isn't real! This isn't real!
All right, 8:55 now. We've been sentencing going on in Hudson, Wisconsin, St. Croix County Circuit Court for about 25 minutes now. The reason why we can't bring you in the courtroom, a pre-hearing decision by the judge to not allow any camera recording, any broadcasting, any live streaming of victim impact statements. But I am getting our first set of notes from our reporters. We have both Karen Scullin and Bill Keller at the courthouse, Fox 9 reporters. Elena Hernandez spoke first. That's Isaac's mother, talking about Isaac's stolen life, and in losing Isaac, stole her own life. This is not, my son did not die in an accident. He was killed by an evil monster. Continuing, she hopes this monster suffers every day until he goes to hell. Her words there. Again, a reference to monster, wishing him a trip to hell. She does ask the judge to sentence Miu to the fullest, which we've talked about now just on the count alone for Isaac. That's 40 years in prison, 20 years on supervised release, and then potentially, although maybe unclear exactly how that 5-year escalator works, but she's asking for a big number there. We also now know Donnie Hernandez, so that's Isaac's stepdad. He was basically raised by Donnie Hernandez. Donnie Hernandez also giving his victim impact statement, and I understand now we were an aunt as being allowed to speak, talking about Nicolae Miu's choice not to walk away from the encounter with the teenagers, that the loss of Isaac very much impacted her life as an auntie, and that she would do anything to get justice for Isaac, and that she is in weekly therapy because of what happened that day. So again, not surprising, some of the verbiage or some of the statements coming from Isaac's family. This is their moment, this is their time to speak, and clearly they are opening up, and it doesn't sound like, I don't want to speak towards the forgiveness or anything like that, but clearly they are seeking the maximum here.
Absolutely. There's no question. I mean, we saw from the testimony of Isaac's mom just the pain that she experienced in losing her son, the pain in terms of the involvement, seeing what she did on the banks of the river, and then, every day she's without her son. And so it doesn't surprise me at all that these are very powerful statements that are coming from Isaac's family.
Yeah, just a little bit more. What about Isaac's dream? Asks the family. He's the most beautiful young man, wanted the best for everyone. Blessed to raise him as my own child, meaning, stepdad there, and be called dad by him. Again, just reiterate, I know a little bit about Isaac, and that he was a 17-year-old junior. He loved golf. His parents live on a golf course out there in the Stillwater area. He had started his own business, like detailing, cleaning cars and then boats at the marina on the river. Engineering, I think I seem to remember Elena mentioning at one point had dreams of maybe attending college at Madison. I know the family has subsequently begun a foundation in his name, the Isaac Schuman Foundation. In fact, one of their annual fundraiser to raise money is coming up on Monday out at the golf course in Stillwater. They're raising money for scholarships for kids who basically have entrepreneurial dreams like Isaac did. And obviously, the tragedy is unfolding in that courtroom. I think it's important to share in the context of everything we've experienced with allowing us into the trial, but the judge has spoken on this front. What I'll be curious about, Debbie, maybe you have an opinion on this, is whether some of the stabbing victims might want to speak today. I do know in one of the court filings that some of them are being allowed to attend via Zoom. That's obviously a new age kind of thing, right? That 5 years ago, that wasn't an option. They'd have to show up for sure. I know they didn't want to speak in the aftermath when I sought interviews with some of them about the verdict, justice, what it means to them. I think there's a lot of regret from a lot of people. I don't know, you've been part of a lot of cases in your career. Would you expect an A.J. Martin to show up and show the judge his scar again? Would you expect a Ryhley Mattison to talk about how she was nearly killed that day? Would you expect to hear from a couple of those types?
Yeah, I would expect that they provide input in some way. It may not be being there presently. It may be a situation where they provide a written statement. You know, based upon the coverage of this case, you know, I understand that there's been a lot of social media voices that have spoken in favor and against each of these individuals who are involved, and so that may play into their decision whether or not to make a statement. Although cameras aren't allowed, the reality is we're going to get information about what has been said. And so I would expect that they provide input in some way, whether it's in person or it's something that's being read. I definitely could see some of them submitting things in writing.
Yeah. My latest note comes from Karen Scullin. Again, she's in the courtroom not too far away from him, but says the defendant, Miu, keeps wiping his face with a tissue. It's unclear if he's crying. She can't quite see. Obviously, she'd be sitting behind him, but his head is bowed, his head is down. Dad is now speaking, so stepdad has spoken. Father's up, creating a deep and painful void, he says. It's a constant struggle for him. It's a void that can never be filled, obviously filled with loss and sadness, and that he struggles with post-traumatic stress from the loss and the tragedy. And of course, not only is it the tragedy of losing a son, it's then this all played out on video. They have to go through the court process, the medical examiner. This has been a grueling, I mean, it's not just, I lost my son, as the mom said, in an accident, and it's tragic, and you sort of deal with it from day one. This is something now that's 2 years on, and this will close one chapter, but you know, then there are likely to be appeals. But I know you represent the defendants a lot of times, but you certainly know the suffering on the other side.
Absolutely.
Could you speak to the humanity on that front over a 2-year journey through the courts?
Yeah, their ability right now to give these victim impact statements, it's really powerful, and it's really important for their healing process. When they're at trial, they can only testify to that which is asked of them. And there are strict rules around what can be said at trial. Here at a victim impact statement, they can actually talk about what they want to talk about, independent of the rules of evidence, independent of the rules that the judge puts in place. So here, this is an opportunity to really express their emotions and to talk about their loved one in the way that they want to do so. And so it's very important. It's important for healing. It's important for some closure, as you said, in terms of this chapter. The appeals generally are things that, of course, they will keep up on, they will be made apprised and aware of, but it's not that they're going to have to testify. They're not going to have to do that at the appellate level. And so for them, hopefully they can start moving forward and continue their journey of healing.
How important, I know every family is going to be different, but is that number, do you find when you're in that courtroom? Are there, you know, do people put a certain number on justice, the number of prison years? Will this family come out of court, their mood very much depending on what Waterman hands down?
Well, I think the state would have prepared them, and the reality is there is no number that will bring their son back. There is no number that will take away that pain. And so the state would talk to them about the fact that, yes, we are seeking the maximum. Again, that's what I expect. But the reality is, whatever number it is, he was convicted. There has been justice for Isaac. And so, you know, if of course the judge were throw the Hail Mary and do probation, I definitely think there would be a lot of anger and hurt. If the judge does something less than the 40-20, I would expect to hear that they are disappointed with that, but they should have been prepared for that.
And you know, again, to that point, is that a jury found him guilty, right? That as Aaron Nelson, the defense attorney, had said, self-defense is a community standard, and if the family takes anything solace or whatever it may be, a jury of 12 from that county, St. Croix County, western Wisconsin, they found him guilty of a reckless homicide charge and made clear, at least subsequently in my reporting, that they never really considered self-defense. They just did not believe that guy. So the court system, the justice system has spoken in that sense.
Absolutely. And for the family, for the jury to disregard self-defense, to them that means, you know, their son, and no one deserves this, but when the jury says this wasn't self-defense, for the family, their son didn't deserve this. This isn't something that he initiated or that his conduct caused. And so for the family, they definitely would hold on to that, and that's important to them.
And this is an interesting development from court. A.J. Martin is giving a victim impact statement right now, per my colleague Bill Keller in the courtroom. Talks about him clinging to life, the breathing tube. We know he had to be resuscitated, that the medical teams working on him in the immediate aftermath of that stabbing, July 30th, 2022, had to revive him a couple of times. The scars hurt all the same. He's very self-conscious of the scars on his body. That's again another compelling victim impact statement to hear directly from A.J. Martin. I mean, and we heard some of it during his testimony, his talking about what his injuries and yeah, he very well, there could have very well been two deceased victims that day, but A.J. Martin now speaking in that courtroom.
Well, that's interesting because I could have seen the state choosing to put A.J. last because in terms of the severity of injuries, obviously the deceased is the most significant, but A.J. Martin's were next. He was the gentleman who essentially was disemboweled. He had the large scar on his abdomen. As you said, he had to be resuscitated. So I could have seen strategically the state choosing to put the two most significant of injuries, the beginning and then at the end. So they haven't done that here. So I will be interested to see who's next. Right. Is it Ms. Mattison? Are they going to go in descending order and then concluding with Ms. Coen, or are they going to jump around a little bit?
Yeah, we'll see. We just don't know. The district attorney's office didn't provide us with any rundown. AJ could be the only one who wants to speak in person, because at least I was getting some indication from some reporting from some courthouse sources that perhaps we wouldn't hear from any of the victims. So the fact that A.J. Martin, what I don't know, just because the way the notes are coming in from our team, is if he's there physically in person or if he's delivering his via Zoom, because we do know some victims are being allowed to attend this hearing via Zoom. And here's a direct quote, again, A.J. Martin, one of the stabbing victims, quote, "I was gutted and died for 9 minutes. 9 minutes. It was straight out of a war movie." They said how the doctor, that's how they said, doctors described his injuries, was straight out of a war movie. So he's going there. He's telling him his impact on his life, and presumably his victim impact statement will close with a plea for the maximum.
Absolutely.
I don't know, the defendant, he's probably got some thoughts on what eventually he wants to say today.
Oh, yeah.
I can't imagine he's figuring how to weave stuff into what he's going to say based on what he's hearing now, right? I mean, obviously the attorneys have the wherewithal maybe to take it all in and process this, but it's a tough time on your side of the bench in this hour of victim impacts, isn't it?
It is, and I would anticipate that in fact Mr. Miu has his statement written out, but the reality is he's human. He's hearing this, as you had indicated, we're receiving reports that he's wiping his face. There's no way he could not be impacted by these statements. So I wouldn't be surprised, even if something is written out, I wouldn't be surprised if he goes a bit off script just to address some of the things. And it may be as simple as just extending apologies directly to those individuals who are present or who are there by Zoom versus an overarching umbrella apology. So I would think that he likely will go off script a little bit, but it'll be a small amount. His defense attorneys want him to stick to the script because their arguments are going to be based on that, and their arguments are going to be focused on his character, lack of criminal history, and hopefully his remorse for what his actions caused.
I'm bringing our viewers up to speed here, coming up on 9:08. We've been inside the Hudson courtroom, St. Croix County Circuit Court, for about, coming up on 40 minutes. We're in victim impact statements. The judge not allowing these victim impact statements to be recorded, shown, live streamed. We have reporters that are feeding us notes. I can clear up at this point, A.J. Martin, he was in person, again, disemboweled, dead, 9 minutes. Doctors describing that he was a victim that basically came right out of a, quote, war movie.
It's more powerful in person.
Yeah,
so I would think
the strength.
Absolutely. I would think the state would encourage them to be there in person, but for some it may practically be an impossibility simply because of scheduling and travel, and for others they just may not want to go back into that courtroom where they had to tell their story. But the state would definitely try to get them there live.
That's a good point. I do want to just another news development. Ryhley Mattison, the second sort of most significant injured We had done the story with her at the time from her hospital bed as she was recovering. She's Madison Coen's friend. She gets stabbed. I don't remember the exact details in terms of the injuries, but certainly had some significant internal injuries that created some lifelong impacts on her. She is giving a victim impact statement via Zoom. So she's the first one via Zoom, and A.J. Martin thus is not the last victim to provide a statement. Every conversation, this is Ryhley Mattison speaking, every conversation I have, I always circle back to that nightmare, meaning that day, July 30th. She's jumpy now, hyper vigilant. She says it is just living a life of exhaustion because of kind of her experience and the nightmare she's has had to endure because of what happened to her and obviously her friends. Now, important to note here, just for those of you perhaps not totally familiar with this case, this group of people who were stabbed, the A.J. Martins, the Carlson group, we came to know them, Dante, Tony, Carlson, Ryhley, A.J. They didn't know Isaac Schuman and that Stillwater group of teenagers. Those two groups were tubing separately that day on the Apple River in western Wisconsin. But what had happened was that commotion started between the Stillwater boys, Isaac Juan, Alex Vang, some of the others in that group, and Nicolae Miu. They kind of heard the rising volume. They were concerned, and that other group then came over. And that, you know, I know they came over to help, and I know we talked to your colleague Marsh Hallberg back at the time during the trial about just the what if game, and if people had just made different decisions. You know, the Carlsons come over at the behest of the dad. And I'm blanking on his first name, but that he had encouraged his sons to go over, Dante and Tony, to help, and really they ended up escalating. Madison Coen certainly helped escalate. She thought she was just trying to get Miu away, and yeah, just a lot of what ifs.
Yeah, and that's something that they're all going to think about that. Mr. Miu is going to think about that, but you can't rewind. And so here, had that group, instead of focusing on Mr. Miu, had they turned and focused on the boys to try to bring them down as they were yelling different things, it may have been different.
And Debbie, with that, we are told Ryhley Mattison was the last victim impact of the day. So the camera feed has just come up, 9/11. So we got about just less than 45 minutes of victim impacts. We are getting our first look at Nicolae Miu. He is, as I suggested, in orange jailhouse jumpsuit. There he is on your screen. The defense had made the request to give him some respect today, let him come in civilian clothes. The state fought that. The judge ended up rejecting that request from the defense, so he's in orange jailhouse jumpsuit. His head is bowed. Our reporter said it's been bowed through all the victim impacts. Let's see if the courtroom audio is up.
We talk about this 30-second incident. But I think it's important to remember, too, the only reason he was by this group was as they were floating away, after he was insulted, he charged up onto the boys and grabbed onto their tube. I'm going to start by talking about the seriousness of the offense.
Are you going to project on the monitors?
Yes. I just have a exhibit labeled Exhibit 1. It just has 2 photos on it.
You ready?
Yes. Obviously, a homicide, any homicide is serious. In this case, Nicolae Miu killed 17-year-old Isaac Schuman. There's very little I can say about the effect on the victims that hasn't been said or expressed better by his family, both at trial and today with the victim impact statements. Part of what makes this so tragic and horrific is how easily Nicolae Miu could have avoided all of this. As I said, after he was insulted, he could have just let the boys float away. Instead, he charged up onto them. When the boys were yelling at him to leave, he doesn't. When another group comes to intervene to help to yell at him, tell him to leave, he doesn't. Instead, while multiple people are telling him, pleading with him, yelling at him to leave, he's smirking and he takes out his pocket knife. The defense filed a memo that presumes that Nicolae Miu actually believed his life was in danger, and that belief was just unreasonable based on the verdict. I don't think that's the case. I think the evidence shows he snapped, as we argued to the jury. I think that's evidenced in his attempt to flee afterwards to avoid responsibility, and his washing the knife, ditching the knife, saying nothing to his friends and family that were there. His playing dumb with Sheriff Knutson when he's first apprehended, acting like he didn't know what happened, saying he saw what looked like kids being kids. Maybe they were fighting. I think it's shown by his countless lies in his interview with Lieutenant Hart. As he's standing there smirking, as we all saw in the trial and the screenshots in the video, holding his knife, he never raises his knife. He never says, "Get back," like any reasonable person would do if they're afraid. I think anybody who's studied self-defense statistics whatsoever knows how many potentially violent situations are diffused simply by somebody pulling a weapon if they feel threatened and saying, "Get back, I have a weapon." He didn't do that. He held it down by his side where nobody saw it. After he took out his knife, when there's just two small females standing in front of him, he then punches Madison Coen in the face, starting the physical altercation. It had, up to that point, been strictly verbal. Understandably, unsurprisingly, after he punches a barely 100-pound female in the face, he gets hit back, and he gets up and starts stabbing anyone within reach, regardless of their role, what they're doing. Ryhley was just standing there, as witnesses testified. Even after his friend Ariel was there, even after he'd stabbed multiple people, even after AJ is disemboweled, trying to hold in his intestines, Nicolae Miu, instead of going back to his group, walks away from them, up to Dante, and stabs him in the chest. There's nothing that shows other than vengeance, because Dante had punched him. So he was going to get even. And then clean the knife, ditch the knife, and return to his group. He encouraged his group to leave. He never called 911. He never tried to help any of the victims. He casually floated by the carnage that he left. Members of his group saw people getting CPR. But for the prompt response from the Sheriff's Office, Somerset Police Department, AJ likely would have also died, also but for the medical intervention. But for the prompt response from law enforcement, Nicolae Miu might have gotten away. He tried, once he got to the exit, tried to walk past the first officer. It was only because of the video and the screenshot that was circulated by law enforcement and witnesses that he was found. Because law enforcement thought they were looking for a single person, shirtless. Miu had changed his appearance, put on clothes, hat, sunglasses, and tried to just disappear with the crowd. In his interview, he made up many bizarre lies, some of which I think show his own state of mind, including his own recognition that he should have just left, because he specifically told Brandy Hart, Lieutenant Brandy Hart, "They told me I couldn't run away." Obviously not true. That's what they were begging him to do. He said, "I don't know why they wanted to scare me with knives." Not true. He was the one with the knife. He said he absolutely did not have a knife. Obviously not true. He feigned to not know the state of the other people. When he was told that 4 people went to the hospital and 1 was deceased, he said, "Oh no," as if he didn't know and he hadn't floated by the carnage that he created. The river was running red with blood. AJ Zid disemboweled and he pretended to not know. The defendant's actions, as we've heard today from the victims, affected so many people beyond Isaac and the other stabbing victims and Madison Coen. It affected his friends, his family, classmates, teachers, the friends and family of the other victims, innocent bystanders around the river, the sense of safety in our community, and what's otherwise known as a recreational area. We heard from the victims earlier the lifetime physical damage as a result of this for AJ and Rylee. There's obviously a lifetime emotional damage for all of the victims and family. Dante and Tony were lucky, no vitals were injured. Madison Coen, for the battery, her injuries were pretty minor. It was pain, essentially. But she talked to the PSI writer about the emotional trauma from this event, as we've heard from other victims this morning. When we first met with Madison, she told us similar things that she told the PSI writer, that about how when she got to shore, Isaac, who she didn't know, was there getting CPR, and that Isaac's mom showed up. And Isaac's mom was holding his feet and saying he's going to be okay, and sobbing. And Madison, sobbing, telling us this, said she decided she's never going to have kids because she can't stand the thought of suffering trauma like she witnessed with Isaac's mom on the shore. Proper consideration for sentencing, as outlined in Galleon, is the character of the deceased in a homicide. We've heard about Isaac from his family. His mother also provided us with some letters from other friends who aren't victims, describing what kind of person Isaac was. His friend Alex Vang, who was with him on the river, described him as always wanting to make sure everyone was happy, always cracking jokes, generous, talked about how they'd spend times talking about their dreams and goals after high school. He said Isaac was one of the people who inspired him for his future because of how driven and motivated and energetic Isaac was. He talks about anger, grief, and guilt following this incident. Landon Wire, who was with Isaac, talks about how this has affected him, loss of one of his best friends, about how he'll be scarred and traumatized by seeing the blood, the guts, and losing his friend, about how he'll never get the chance to grow because of the actions of Nicolae Miu. Juan, who filmed the video, hopes that justice will be served and his conviction is a step forward, but talks about how he'll never replace being able to see Isaac again, having one more hug, telling him he loves him. Isaac's girlfriend, who he'd known since middle school, talked about how they were looking forward to the future and what kind of house they would buy. Described Isaac as hardworking, intelligent, caring, charismatic, funny, and loving young man. That she knows he's protecting her and his family now. Character of the defendant is also relevant for sentencing. The defendant's 54 years old. As the PSI talks about, he came here from Romania when he was 15, worked as an engineer, had no criminal history. He's been divorced 3 times. He has one son who lives in Romania, who he hasn't seen in 10 years. One odd thing from the PSI I noted is he spoke very highly of his dad and denied any abuse from his dad. But there's a public restraining order where he and his brother said that they're abused by their father. I don't know how relevant it is, it's just a little bizarre discrepancy I noticed. He talked a lot about his own struggles, about how he's depressed and his health issues. In the PSI, he talked very little about the effect of his crimes. And that's been a present fact throughout this case, is no remorse from the defendant. You'd think, one would hope, even if he truly believed this was self-defense, he would at least feel sorry that somebody was killed because of his actions. There's been no evidence of that. At trial, he was only emotional talking about his dog, never emotional about the horrific injuries or the death of Isaac. I'm sure his attorney, and maybe even himself, will talk today about how remorseful he is. I think that rings hollow. Every defendant claims remorse at sentencing. What's much more enlightening about how he truly feels is how he acts, what he said leading up to today. All he really mentioned in the PSI that would suggest remorse is he is very sorry for everyone involved. No specific mention about killing Isaac Schuman, a 17-year-old, or the loss of Isaac for his family. Throughout trial, the heartbreaking testimony of Elena and the other witnesses and victims, there's no emotion from him. And I believe his true feelings are evident in his calls with his brother. He has numerous jail phone calls with his brother speaking Romanian, or perhaps he was a little less careful about what he was saying because he thought maybe it wouldn't be translated. He has a tendency, well, one, he consistently disparages the boys. He has a tendency to refer to them as other than human. There's no, and defense can correct me if I'm wrong, there's never any hint of remorse for his actions. Instead, I'll just read from one section. He says, "At jail, these bastards got me here. Well, it is what it is, but at least I'm alive. I was able to fight in order to survive. You got it? At least I survived the attack. And now look, the bastards are free. The bandits from hell, they are free, and I'm here. I'm victimized again." No, the bastards are free, and I'm here. No acknowledgement whatsoever that Isaac is not here. He killed Isaac. I'm sure there's going to be a large attempt to paint him as this great person. His jail phone calls, I think, tell a different story. He refers to Lieutenant Hart as a dirtbag policewoman, that wretched lady, suggests she's hiding evidence. The common theme is throughout his calls, he can't accept any personal responsibility. He blames Lieutenant Hart. He blames his own group, including his wife, for not stepping in. He also can't stop lying in his phone calls. He maintains there's other knives. He maintains with his brother, even well after he's arrested, after he's seen evidence, that he didn't take out the knife until after he was attacked and down in the water. That is undeniably untrue. You can clearly see him in the video before anything turns physical, smirking and holding that knife with the blade open. He claims he didn't try to leave the scene, claims he tried to run away from the confrontation. His continued lies, no, even he knows it's not self-defense. He didn't think it was self-defense. He knows it's absurd when if somebody looks at all the facts, to claim self-defense, so he continues to twist them, even with phone calls with his brother. As well as that section I read where he described the boys as demons from hell, he describes them as bamboo bastards. But most often he refers to them as bastards. At one point, expressing frustration that his wife and friends didn't get to help him, we get a little bit more insight into his thought process. He says, friends, but when it's about a fight, they don't come to intervene. Man, had it been Sandy in that kind of situation, surrounded by those guys in the water, I would have rushed there, terminating those guys. There's so many, like you said, it would have been more of them like that, bellies up. So that's the cold and callous way he refers to killing Isaac, as leaving him belly up. Obviously, he's still angry. As we argued in the trial, he was angry at the time, he wasn't afraid, and he's still angry and accepts no responsibility. Clearly has no idea that self-defense is meant to stop a threat, not to terminate people and leave them belly up. I'm sure defense is going to spend a lot of time talking about his lack of criminal history. It's not unusual we see horrific crimes committed by somebody with no criminal history. I'm sure there's going to be a lot of discussion about him being a peaceful person. A peaceful person doesn't rush up on a group of teenagers because they insulted you. Doesn't refuse to walk away. A peaceful person doesn't take out a knife when they could have just walked away. Doesn't start a fight and stab 5 people. I think there's more, a big question in this, I think defense is going to argue, is he's not a danger to the public. One, I think the crimes speak for themselves. Clearly he's a danger. No reasonable person in his situation would have acted like he did. This would have ended before it was even anything. Talking about leaving people belly up and terminating them is not the words of a peaceful person. His lack of remorse is certainly an indication of his lack of respect for human life. His dehumanizing the boys, including Isaac, with this terminology he uses to describe them. Another thing that's perhaps a clue that maybe this shouldn't be that surprising is when law enforcement went to his residence after he was arrested, they got consent from his wife to search his Jeep. In that Jeep, they found a machete concealed. Can we have the screen? That was concealed between the center console and the passenger seat. When law enforcement asked his wife about it, she said, described that he has that for protection for possible road rage incidents. She then later said, well, actually, maybe it's from camping. I think nobody hauls camping material, camping equipment, concealed where it's in easy reach of the driver. It's absolutely bizarre that somebody would decide, one, that they're so concerned about road rage that they have to carry a weapon. I completely understand people conceal carrying, but to do it specifically because of road rage is strange. But absolutely bizarre is choosing to carry a machete. That makes no sense to me. It's not a defensive weapon if he's attacked in a car. It's only an offensive weapon because he'd have to get out of his car. The state's recommendation is a total of 60 years initial confinement. For count 1, for the homicide of Isaac, the state's recommending the maximum sentence of 45 years initial confinement, followed by 20 years extended supervision. For the recklessly endangering safety, counts 2, 3, 4, and 5, the state's recommending 6 years initial confinement, followed by 5 years extended supervision. And on count 6, the battery, the state's recommending 1 year, with all counts running consecutively. The state believes a lengthy prison sentence is appropriate to protect the public. It's appropriate as punishment. I know defense is going to talk about that a lot. The reality is that's a proper consideration, whether they like it or not. Punishment is a consideration in sentencing, but mostly to not depreciate the seriousness of the offense. It's hard to put into words how graphic and horrific this was. Everybody saw the evidence at trial. The public didn't see all of it. Some of it we kept or tried to limit what was shown because it was so graphic. The only other thing, Judge, is the state would ask for 30 days for restitution. I believe there will be some. I'm hopeful that we could reach an agreement, but if not, we'd ask for a restitution hearing.
Is that all?
Yes.
Why don't we take a short recess? It seems to be a logical place for a break. We'll come back at 9:45. Mr. Miu and his attorneys will be escorted to the waiting room. We'll reconvene in 10 minutes.
All right, taking our first morning recess, 9:34. So we know we had to rejoin the courtroom late, and that the victim impact statements were not allowed to be shown on camera, but everyone in that courtroom has now been seated there. Some intense, obviously, victim impact statements, and now the state has made their ask for what they want to see Nicolae Miu sentenced to, and they are, I mean, it's not a full maximum ask here, but certainly
very close.
would amount to a life sentence for a 54-year-old, 40+ years for Isaac Schuman's death, another 24 years initial confinement, meaning prison. You do that amount of time, so 24 plus at least 40 there, 64, another year for Madison Coen. I mean, you're getting up towards 70 years in prison in all. We're not exactly sure. He may have misspoke a little bit about a 5-year. There's some confusion in the math, but certainly upwards of 70 years is the ask of initial confinement, meaning the time you do. Your thoughts as Debbie Lang, local criminal defense attorney, joining us for some legal analysis. Debbie, your thoughts on that request?
Not surprised at all. Not surprised that the state's going big, and not surprised that they're asking for consecutive sentences. So sentences that run one after another, not on top of one another. So the fact here that they're asking for the maximum under the law in Wisconsin for Isaac Schuman's death, and then the state came and asked for a bit less than the maximum they could have for the endangering of the other individuals. They could have asked for up to 7.5 years confinement for each of those counts, and instead they asked for 6 years confinement on each, followed by 5 years of supervised release after Mr. Miu is released from prison.
Was that a pretty standard argument from a prosecutor in a case like this? I mean, he quoted from what we talked about, the pre-sentence investigation, meaning sort of a full in-depth investigation into the defendant's history, in this case, Nicolae Miu, citing a lack of remorse. He had some very disgusting language, frankly, about the boys that he encountered that day, the crowd, the tubers, a lack of remorse. I mean, we saw the machete at the end that was kind of found in his vehicle after the incident. But was that a pretty standard argument that you would see at sentencing?
Yeah, as anticipated, he hit those 3 points that the judge has to consider. The judge has to look at the nature of the offense. That's where the prosecutor specifically discussed the horrific nature of this offense, the fact that Mr. Miu tried to conceal his identity, didn't render aid, tried to hide the weapons, the lies. That's all focusing on the nature of the offense. Then he moved into and spoke about the character of the defendant. In that, he pulled those jail calls. All calls when someone is in a correctional facility, they are recorded, and they can be pulled by law enforcement or the prosecutor, and one doesn't have privilege with those calls if they're speaking to someone other than their attorney. And so we did hear very powerful and, as you said, shocking language that was used during those calls when speaking with his brother. So the state focused on that to attack Mr. Miu's character. And then finally, they spoke about need for protection of the community. That's where the machete comes into play, and why that machete is in a vehicle that Mr. Miu is driving about in the community when he's encountering other individuals, right at arm's width to be able to grab and use. And according to his wife, at least her initial statement, he had that for concerns about road rage. So all of the arguments fell into one of those 3 categories that the judge has to consider. So it was well structured in that regard.
And as for the machete, we could talk a little bit about it, given your legal expertise here, is that machete was subject, I did mention it during our trial coverage, it had become a point of emotion during trial. The defense preemptively said, machete's not coming in at trial, and the state didn't necessarily try to introduce it at the trial, but they knew it was in the investigative file. They wanted it out, so it never came in. Jury didn't see that. Had nothing to do, obviously, with the encounter itself. But here at sentencing, books closed, you're showing the judge everything, you're putting everything on the record. Now the state brings it in.
Absolutely. And here the state is allowed to bring it in because, again, it's going to address potentially one, if not two, of those sentencing factors. So the importance of protecting the community with a sentence, as well as the defendant's character.
Couple points to make. Again, we kind of hopped in. We lost the victim impact statements. That was a judicial order. That was not a decision here at Fox 9. Judge said we could not record and show the victim impact statements. But once the camera came up, we talked about Nicolae Miu the defense had made a request to let him show up today. Civilian clothes. The state objected, and clearly Judge Michael Waterman said, yeah, you show up under the current policies and procedures of the jail. He's in the St. Croix County Jail, has been for 2 years. He was never able to make bail, but the judge did revoke any chance of bail after he was convicted. So he's been in jail, and policy and procedure there, orange jailhouse jumpsuit, and you'll even see he's handcuffed and shackled at the feet. So he's sitting there observing this, taking this all in, as far as our reporters have said in the courtroom during the several victim impact statements. We heard from several members of Isaac Schuman's direct family, mom, dad, stepdad, an aunt, and then we heard from a couple of the victims who survived, A.J. Martin, who's in the courtroom. You could see him behind one of the camera shots, and then Ryhley Mattison apparently provided her statement via Zoom. Now we turn the page to the defense. When we come back from break, it'll be Aaron Nelson and Corey Girafasi's opportunity to rebut that, ask for what they're going to ask for. So this is you. This is Debbie Lang. You've done this a gazillion times. What are those two attorneys doing right now as they prepare to make a counter argument for what they think Miu should face?
Yeah, well, they've submitted some arguments, and they have submitted some letters that attest to their client's character. So I would anticipate, they're not going to read those, of course, because they trust that the judge has done that. Instead, they're going to be pulling key components out of those letters, focusing on those. I definitely believe that they are going to have to address these jail calls in some way. The argument of the state, that's not the first time the defense has heard of this. They would have had to have been put on notice, and so they're going to be prepared to address that. Also, as you saw, both defense attorneys were taking notes while the state was presenting their argument. They're not going to hit on every single point that was raised by the state, but they'll certainly pull out some of those to try to, again, address those three characters that need to be discussed during sentencing and try to dampen the effect that the state's arguments had. And Paul, I do think it's important to note, just for your viewers, that when it comes to a defendant who's in custody, being in the orange and being shackled, that's standard. So even if someone is in custody for a property offense, they're still going to be shackled as well. That's not an indication that the judge feels that Mr. Miu is a greater danger than anyone else. So I think that's really important to point out, that it is standard. And again, for a jury, they would have no reason to know that. The judge, of course, does.
And during a trial, you wouldn't want that, whatever that imagery creates in the mind of a jury, you wouldn't want to prejudice any sentiments they may have. Look over. Of course, he's guilty. I mean,
he's
if
in
you
custody.
saw someone like that,
Yep.
You might think that. How delicate of a dance will it be for the defense here? I mean, clearly at trial, there's part of their strategy in creating the self-defense, storyline or defense was, those the victims here and those involved. They were scary, they were mean, they kind of created it. You heard the state sort of say, Nicolae Miu hasn't come to terms with humanizing those people involved. The defense, I know they still believe this was self-defense, but they're now just speaking to the judge, not a jury. So how do they delicately talk about kind of still blaming others for what happened that day, but arguing for a lesser sentence?
Yeah, they're definitely going to bring up the components that they feel supported self-defense. The fact that there were so many people, that the other tubers had escalated the incident, they were the one yelling, circling in on Mr. Miu. I anticipate that they're going to bring that up, and the reason is, again, the nature of the offense. It's something that the judge is to consider here. And so they're going to touch on it, but I wouldn't see them going so far as saying, it's the other tubers' fault. The other tubers could have walked away as well, and it was a split-second decision that was made by everyone in terms of how they were acting. So I would anticipate they're going to touch on it, but I don't think they're going to stay long.
You saw something just when the camera was obviously tightly, trained on Nicolae Miu, and this is interesting. We have a slightly different angle because during the trial itself, the camera was at a different point because the jurors, we didn't want to risk, showing a juror accidentally. But clearly here we moved, my belief now is that the camera's actually in the jury box facing Miu straight on. We don't typically get to see the defendant from the face. I mean, as someone who covers these cases, I'm always behind the defendant, so it's providing us a unique perspective. And I know you're not a psychologist or anything, but you saw something in kind of Miu's demeanor, his head down. He didn't appear to be looking at notes, didn't appear to be, I don't want to say he wasn't processing it, but certainly his head bowed. But you saw something that maybe you wonder if he's going to speak today.
Yeah, while they were panning on him, he appeared to not be looking at notes or not reading something. And it's very common, especially when the state is presenting their argument. It's very common that we tell our clients, obviously you should be listening to that, but when the state's making their argument, start looking at yours. Your time is coming very quickly. And so it didn't appear that he was looking at or reading anything. And so I had made a comment to you, Paul, that, is there a chance that he's not going to make a statement or he's going to make an extremely short statement? That is a strategic decision. And now that we know about these jail calls, that becomes a more viable possibility at this point in time. That defense says, hey, let us argue this, because those jail calls, those are damning and those are powerful. And so it is possible he may not do it.
Is this the first time the judge would have heard about the jail calls, or would that, I don't know if they'd make it in the PSI, would they? That would be state information. So yeah. I don't know if I haven't checked the case in the last hour. I don't know if the state submitted any arguments in advance, or could Judge Waterman be hearing about that type of behavior for the first time just now?
It would be unusual. Generally, the parties would have notified the judge about that. Again, here, there may have been some other legal arguments that were made regarding those calls, but again, they're not confidential. The individual in custody knows that they're being recorded. There are signs up over the phones. There's an audible response that when the defendant calls an individual, it says the call is being recorded and is subject to review. So you know it. And so certainly the state gets to use them and is able to make those arguments. But I would be surprised if this was the first time the judge was hearing about it. Also, the way that the state presented it, if it was the first time, I would have anticipated that they put transcripts on the board, something to really help it sink in with the judge.
And you did remind me there were arguments made during trial very specific to some phone conversations with his now ex-wife, but his wife at the time, and what the judge was going to allow to be played. And it was a very small amount. Again, I think the judge recognizing some of the prejudicial value had you presented some of that inflammatory, demeaning, kind of horrible, language to a jury. Our camera has come back up. You can see Judge Waterman's nameplate there. During trial, we would show you the state seal of Wisconsin, but perhaps we have a new photographer in court zeroing in on that, but certainly would seem like proceedings are imminent. We'll keep an eye on this as we go. Is there a typical length of time you'd expect a defense? I mean, would they go a little bit longer than the state just because they may have a little bit more to say about it?
Yeah, generally. The state's argument wasn't extremely long here. I didn't time it, but my gut on it, maybe about 20 minutes or so. I would expect it to be a bit longer, and I see the judge now.
Yeah, Judge Waterman, let's take you out to St. Croix County Circuit Court, Hudson, Wisconsin.
Okay, we are back on the record. The attorneys are present along with Mr. Miu. Mr. Nelson, will you be delivering Mr. Miu's argument?
Yes, Judge, but I believe the state had something to add before I start.
I just noted my total was incorrect. All the specific lengths I gave for recommendations is correct. The total of initial confinement is 70 years.
Thank you. Mr. Nelson.
Thank you, Judge. I just want to start by obviously acknowledging that this was a tragedy all around. We completely understand and appreciate the heartbreaking loss and the grief that was suffered by the Schuman family, the other victims, and their entire family, their friends, everybody here in the courtroom for the most part. It's obvious that Isaac Schuman was a unique and special human being that was loved by innumerable people. As Your Honor knows, here today, defense has a unique role in this process. And so while as a human being, I definitely heard what was said, I'm going to focus on our role today, and I'm going to focus on the galleon factors. And the galleon factors, as we all know, and we'll talk about it later, talk a lot about Mr. Miu, the seriousness of the crime, and the need to protect the public. So I just want the court to know, and obviously the public to know, that we heard the victims. We understand and appreciate that. I'm just going to move through and talk about the galleon factors. I think it's always important to, when I think of galleon, which I think it was cited in my sentencing memo, Your Honor, and I'm sure Your Honor's heard me say this before at other times. I've been in front of Your Honor numerous times. But my favorite quote in all of Wisconsin jurisprudence is from paragraph 36 of galleon. Experience has taught us to be cautious when reaching high consequence conclusions about human nature that seem to be intuitively correct at the moment. Better instead is a conclusion that is based on more complete and accurate information and reached by an organized framework for the exercise of discretion. I know Your Honor knows that quote. I know Your Honor will appropriately exercise your discretion. I didn't mean to imply that you wouldn't, but I think it's good for all of us, and I know obviously the court, Your Honor, is my audience today, but this isn't happening in a vacuum, and I think it's important for all of us as members of the court system to take that real responsibility on when we speak about things of this serious nature, which at the end of the day, this is as serious it gets in our profession, in the criminal justice system, the sentencing. How do we deal with loss within our society, within the court system, within this courtroom? It's a profound question that I think demands incredible attention, and that's what I'm going to try to give it today. That quote ends with the exercise of discretion, and in galleon, again, as Your Honor knows, the courts talk about discretion in a way that makes clear the use of discretion is using the process of reasoning and a logical rationale. And so if you indulge me for a moment, just to quote from paragraph 3, discretion is not synonymous with decision-making, rather the term contemplates a process of reasoning. Paragraph 6, in this opinion we examine the process of reasoning. Paragraph 19, quoting McCleary, the term discretion implies a process of reasoning. This process must depend upon facts that are of record and that are reasonably derived by the inference from the record and a conclusion based on a logical rationale founded on proper legal standards. They go on to say in paragraph 22 more about a rationale, paragraph 39, a rational and explainable basis, paragraph 49, a rational and explainable basis, paragraph 15, a rationale for sentencing. Decisions must be knowable. And I'm going to address that a little bit more when I do get to the, I think near the end, when I address punishment and retribution. Because I think this framework for us here in a court system using rationale to try, maybe unsuccessfully, but to try to figure out what we do as a society when loss has been suffered. And part of that rationale, Judge, is clearly morality, right? I don't want to go on too far about, what's the purpose of the criminal justice system, but I think in many, many, many ways it is a system to try to impart and show our common morality and the morality that we believe in as a community. I think morality, and I think there's hundreds of years of philosophers who support that essentially morality is by its nature both forward-looking and functional. And I think that's a key theme at any sentencing is we're looking towards the future. Obvious, we're here about the past, right? There's been crimes that were committed that he was convicted of. There's loss that happened in the past. But morality in sentencing, I think, at its core is forward-looking and functional. The natural purpose of morality, even the retributive impulse, is to shape future behavior advantageously for our community, for our society. Any reasoned moral response to past behavior must consider the best means to achieve what our community's desired ends are and how most effective we can be on those future offenses. And I say that, and I'm maybe taking some things out of context, but one of the matters that Mr. Anderson addressed, right, in his comments, and I appreciate this, that he was critical of Mr. Miu's actions on the river. And he essentially said, and Your Honor just heard it, so I'm not quoting word for word, but what I heard him say, he was critical because according to Mr. Anderson in the state, Mr. Miu was acting on vengeance to get even. That's one of the things that the state had said. Now, I don't want to get, this isn't the time for factual disputes. I get that. So I'm going to put that aside, whether I agree with their conclusion about what the facts lead to show. But what we know and we both agree upon is that's a recognition that vengeance is an emotion that we ought not promote. Vengeance is not something that we ought to model. Vengeance is not something that I think any of us should aspire to or aspire others towards. Justice is different than vengeance. And I don't think this court, any court, while the natural human feelings of those who've suffered loss may involve those very instinctual, common, emotional feelings that all label vengeance or some sort of strike back. That is not something we all agree we should promote. And my hope is at the end of this that Your Honor will have some words to address that and address the meaning of sentences and the purpose of that and how they may differ from vengeance. So back to Gallion. As Your Honor knows, Gallion cites the law, the starting point for the law on any sentence, even this sentence, and I'm quoting the law. Probation should be considered as the first alternative. That's what Gallion says. It then quotes Bastion, B-A-S-T-I-O-N, paragraph 25, adopted the ABA standard 1.3 relating to probation. And again, as Your Honor knows, and maybe Your Honor will address this in your comments, but this is the framework where we as lawyers in the court of law in a in a system designed by social contract that we've all agreed upon. This is the framework which we do. And it says probation should be the sentence unless the court finds that, 1, confinement is necessary to protect the public from future criminal activity by Mr. Miu. Or 2, Mr. Miu is in need of correctional treatment, which can most effectively be provided if he is confined. Or 3, which I think is what the majority of what we'll be talking about today, I will be, is number 3, or it would unduly depreciate the seriousness of the offense if a sentence of probation were imposed. So with that framework, Judge, I want to talk about those 3 different factors, or 3 different questions that need to be answered. Obviously, within that, Gallion also talks about the 3 sentencing factors, which I think are somewhat parallel, if not consistent with that, and that is the character of Mr. Miu, the need to protect the public, and the seriousness of the offense. So I'm using it in the framework of these 3 questions outlined by the standard 1.3 of the ABA standards. So first off, is confinement necessary to protect the public from Mr. Miu? That's where I think we think of his character, right? And I understand that the state and some of the other speakers today made comments about Mr. Miu's character, and I understand why they may have those opinions. But the facts, the cold hard facts, are that Mr. Miu, prior to this time when he was on the river, has never been in trouble. He was an upstanding, moral human being. He had, as you know, in the sentencing memorandum and in the PSI, but just to quickly outline, he was born in Romania. He and his family, for lack of a better term, were treated poorly there. A circumstance that was outside of his control, and they managed to leave that circumstance and come to America. But like some other things in Mr. Miu's life, that wasn't in his control. He didn't sign up to be born into a communist Romanian country. He didn't sign up to be persecuted in that communist regime. He came here and had what I think we would all consider the American dream. An immigrant, came here, he learned the language, he adopted America, he assimilated into our country, and he was a productive member of society, getting an education, being employed, and having positive relationships throughout his adulthood. The state has mentioned some things about his character that I feel like I don't want to belabor it too much, because I don't think at the end of the day there's really much question about his character. The state's talked about his phone calls, right? What Your Honor probably knows is he's been in custody for 2 years and a day. About 732 days he's been in the St. Croix County Jail. During that time, he's had some phone calls. The state mentioned some of these phone calls. I will just say, without us being distracted by these phone calls, that we dispute the translation on many of those phone calls. In particular, the word bastard. That's not the Romanian word that Nicolae used. I think the proper translation would be an unfortunate. And so that's a very different context in which this was said. Second thing I think is Mr. Miu has been in custody for this time. Like, I think anybody, whether he was involved in this traumatic event, right? He's been suffering PTSD while he's in the jail. That's documented through the jail records, through the medical records. He's been going through his own process. These phone calls that are mentioned, you don't get a timeline. You don't get a date. Many of them, based upon my memory of those phone calls, which wasn't a huge part of the trial, was these happened in the first 30 to 60 days of his incarceration. These weren't from yesterday. These weren't from last month. These weren't from around the time of the trial. These were much, much further back in time. And I say that because remorse is something that the state talked about, and they talked about it in the context of Mr. Miu's character. I think Your Honor knows the criminal justice system in America is good at several things. It's not really good at allowing sometimes a space for a person in Mr. Miu's position to express remorse in a safe space. The only people that he'd be able to do that with are myself and Mr. Cherofisi. I don't want to make myself a witness, but I can tell Your Honor's office of the court, he has processed this. He has shown in the numerous times, the tens if not hundreds of times that I've met with him, remorse over different times in the action. A lot of mixed emotions, probably not one emotion that he's been showing, but there has definitely been remorse. One story that he's given me permission to tell is very soon into this, after the event. The state approached me as his lawyer and asked about the release of Isaac's body. As we heard from his sister, Isaac's body was evidence. That must be a devastating thing that they had to deal with. And Mr. Anderson reached out to me to see if the defense would release the body. And of course, I did my duty. And the first thing I did is I went and I spoke with my client, Mr. Miu. And when I made that question, I approached Mr. Miu with that question, he looked at me aghast. He could not believe that that had not already happened. And he broke down emotionally and wept. He just wept. Maybe there was other things that he came in. Maybe this was a time when I first met him, when we were starting to get to know him. Maybe it's a time that this loss that had happened became more real for him. But in that moment, he showed what I think was remorse. They weren't there to see it. And they weren't there to hear about it until today. And if we could redesign this criminal justice system in a way that maybe we could give some of those things to the victims' families beforehand as we're going through this, I think there might be other healing, there might be other things that can go through. I understand and appreciate why they might feel the way that they do. But I can tell you, I've been with him. I've been with him over those 732 days, and he has shown remorse. Is it mixed? Is it complicated? Absolutely. Are there times that he has some other feelings that are all mixed in with this? Yes. But I submit to you that he has shown remorse, and it has become more and more and more so as we have moved through the process. His character, Judge, at the end of the day, we're here to judge him on his actions, right? He's here because of an action. And I think that all of us as human beings, at the end of the day, we have thoughts, we have opinions, we might make comments, and sometimes our words might be considered actions. But at the end of the day, when you add it all up, you're going to judge me, all of us, the world judges us on our actions. And this day, July 30th, that 2 minutes, right? We'll expand the time limit. That's the first time that his actions, I think, become into question. And what, in any other context, I'm not trying to belittle what we're doing here. It's serious. If I make an analogy that's poor, I apologize. But in any other context, if we were seeing somebody's performance across a field, whether that be in a sport, whether that be in academics, whether that be in a profession, if they've demonstrated through factual data points, and we measured all of their actions, and they had one data point, horrible, glaring, big red data point that's at the bottom of the scale, right? If all of our points are measured across a scale, birth to death, and we hopefully develop and grow as we go across time, and our actions improve on our development of moral development in society. If somebody has one data point that's below that line, common sense tells us in every other capacity, in every other field, you don't overcorrect based upon one data point. And that's why I think his character, and I get that that's just one part of this, I don't want to say it's equation, one part of this analysis, but that's what common sense tells us in everything else. If you objectively measure it with the PSI did, he is low risk statistically. He didn't ask to take the PSI. He didn't ask to get measured on Compass. But it happened, and one of the things that the Compass came back and told us is he's low risk, which makes sense for somebody who's 54 now. At the time he was 52 and had never been in trouble before. That's low risk. That's what the objective evidence, if you were going to use a process of reasoning or rationale, that's what that shows. I do think, and I appreciate that there's been a guilty verdict. I'm not trying to relitigate matters about what happened on the river. But I think when you think of his character And later, when you think about need to protect the public, or when you think about punishment, all of those aspects, we have to consider the circumstances of the event. That's just the plain reality of this. And the circumstances, the factors, the conditions, the circumstances played an essential role in shaping Mr. Miu's reactions. He didn't put himself in that position. I've definitely heard talk, and I will address it later, about could he have gotten himself out of that position in other ways. I understand that, and I'll address that. But we have to know that he didn't put himself in that position. The state, I think even again, in their acknowledgement, right, one of the things that they were critical of him is they said he should have de-escalated by showing the knife. And I'll get to that. But I think that's also just a common sense acknowledgement that somebody else, other people, the circumstances were being escalated by people other than Mr. Miu. He was in that position. There may have been other things that he could have done to do that, but it's not of his necessarily control. So I just, again, we're here to talk about Mr. Miu, and we're here to talk about Mr. Miu's actions or reactions, and you're here to judge those, and you're not here to judge or blame others. I get that, and I appreciate that. But his actions, his reactions, did not occur in a vacuum. Did not occur in a vacuum. The second question, moving on from his character to some degree, is, and again, just I sent Your Honor a letter. There was numerous quotes from all of his family and friend. He's got numerous family and friend that are here. And some of them have even asked me, could I approach, could we say something on behalf of Nick? And I appreciate why somebody would want to do that. My hope is that Your Honor, through the PSI, through the letters that that I submitted, through the letters that other people wrote and that I submitted, Your Honor gets a picture of who Mr. Miu is. And it's, while calling witnesses might help this process today, I don't think it's going to help Your Honor. And at the end of the day, I think my audience is the court. So, what's the next question? The next question is Mr. Miu in need of correctional treatment which can most effectively be provided in confinement? And I think the answer to that clearly is no. There is nothing in the PSI, there's nothing in his character, there is nothing in any of the information that's been submitted to the court that he has any treatment needs. There's been this potential about alcohol. I understand that, right? And one of the things that Mr. Miu wanted me to point out regarding the correction from the PSI regarding substance abuse history, in particular pages 22 through 34. It's probably just easier for me to quote his words. It's not as much a correction as just maybe some things were left out. And his words to me were, I rarely drank any alcohol in college, and when I did, it was beer only, never hard liquor. Rarely drank more than 1 to 2 beers, and rarely until I would get a buzz. I avoided getting a buzz. I did not like beer or any type of alcohol in the beginning at 23 years old. I drank socially only. So that's, again, it's not, I don't think, nobody said that he was intoxicated on that river. The PSI acknowledges that that's not what the evidence was. Was there alcohol involved? Yes. The witnesses that testified, the witnesses that submitted to him, he's not in need of treatment for any substance abuse. There's no other need that he could only get in prison, right? And even if there was, whatever, again, I don't think that there's an alcohol problem, but I think it's undisputed that treatment for alcohol can best be provided in the community. So he doesn't have needs. He's educated, he's employed, he has no record, no past behavior. The treatment, right? I think at some point if we're talking about sentencing, sentencing is about modifying our attempts, the court system, the court attempts at modifying another human being's behavior, right? Either through moral education or giving them other tools, other skills so that they are reduced risk. In this situation, if you're talking about the morality, we have to again consider the circumstances of this event. We have to, right? I understand Mr. Anderson does not agree with my analysis of the verdict. There's probably never going to be an answer as to whether or not, to what degree self-defense was considered by the jury, or whether there's been any factual finding that he, in fact, had an actual belief that he was acting in fear. I think the evidence supported that. My conclusion, as I put in the writing, was that the jury determined that his beliefs were unreasonable, and that's why self-defense didn't apply. Your Honor is going to be able to do that in your own context, so I'm not trying to relitigate, but I think that that's important here, because it's our position that he had a sincerely held belief. Mistaken, wrong, unreasonable, but the jury found it to be reckless. This is not an intentional act that needs to be modified. The state, even though they didn't say that, their implication is what he did was something that's intentional. They talk about his smirking. They talk about his doing other things as if this is something that he intended. The jury denied that. They denied that theory. They rejected that theory. This is a reckless act, and I think when we're talking about how do we modify someone's behavior, you're different than if you're modifying a reckless act than if you're modifying an intentional act. This wasn't criminal thinking, right? This was somebody who was in a situation, and again, I appreciate this people might be overreacted, right? That there was a tool, he used that tool, and he used it to a degree that the jury found to be reckless. But I think that that becomes something that we need to consider, right? There's no treatment modification because he didn't act with malice and forethought. He didn't act with malice and forethought, right? He reacted out of fear. And while that may be criminal, that's something I think that he needs any treatment for. So again, that's all in response to that second question, right? Which really leads us to, I think, the core of this matter. Would probation unduly depreciate the seriousness of the offense? I think the answer is yes. I think the answer is yes. I imagine Your Honor's not surprised that I would say that. But I think we need to think about how that should be issued, right? And I say that there are, what I'm afraid of in this case and in all cases, and in general when we talk about sentencing and we have to make sure it's not unduly depreciated, is that we have an entire system, right? An entire system of justice. That appreciates the seriousness of crimes. And for, I think, anyone, a PSI writer, an attorney representing the state, the public, the media, for anyone to try to simplify it, to say that the only way in which we can appreciate the seriousness of something is a number in prison, a length of prison sentence. I think that that is disrespectful to the entire criminal justice system. I think that that undermines all the other things that we do in the criminal justice system. Because we appreciate, in this part of this whole process is an appreciation of that. And I hope that the public, everybody understands that. There's an arrest. There's incarceration. Incarceration for 732 days, which, as Your Honor knows, that doesn't happen in most cases. Most people are let go on bond. And I'm not critical of the decision to not, but that is obviously an appreciation of the seriousness of the offense. There are numerous court hearings. There is jury selection. We went through the jury selection process in this case through all of those questionnaires, all of the other things to make sure that we get it right. And I appreciate the level of detail that we did, but that is, again, a way in which we appreciate the seriousness of this case, because we don't do that in all of the cases. I know that. We don't. And we should have done it in this case, and we did do it in this case, and we did it because of the seriousness of the case. There's clearly a trial. There's now been a conviction, right? He's now a felon, and he's going to be sent to Wisconsin State Prison System, right? Those are all recognitions of the seriousness of the offense. My complaint might be the wrong word. My criticism, I think, is of sometimes how we do sentencing is that we push all of that aside and try to say we have to do a number, right? It's like a contest. Whoever can produce this bigger number, that's where we go to. That's not what I think we should be doing in the criminal justice system. It should be measured. It should be thoughtful, right? It should be wise. I don't think it's not an equation, right? It's not just simply math. And while numbers are important, we don't value lives with a number. We don't value character of people by a number. There is no way that we can put into numbers the loss that the Schuman family has articulated. And I get that. I also get the desire to try to do that. But that's not something we can accomplish. We just can't. I wish we could. I really do. As one human being to another, I wish we could. But how, again, I'm not trying to imply how we in this system, we use our words, right? We use our words to explain things as Gallian things. And I think it's to explain things in a moral sense. It's too simplistic if we rely upon a number. And it undermines the evaluation and the appreciation of all the other aspects of the criminal justice system if we do that. Again, duly depreciate. Appreciation, I think, is about the future and deterrence, right? There's no science, zero research that any sentence that is given in a case is going to deter others. It's one of the most studied things within the criminal justice system, and general deterrence, there's no evidence that that works. So while I appreciate the desire for that we want to do that, we want to do something here that is going to change the future for the rest of the world. I get that. That's a wonderful desire to have. But the science says that's naive, that's not what's going to happen, because that doesn't happen. And I think it's even more so in a case where we're talking about things of a reckless nature rather than an intentional nature. And here's where I think I need to go back and address some of the thoughts that people have about Mr. Miu, and I understand why they would have those thoughts, and whether it's the state calling him a monster or evil, or whether there's other people, right? I don't think that helps anything. And here's why. If we're really trying to craft a sentence that is going to have some influence on people watching, people who read this, people into the public, right? If the court system says he's, and I don't think the court would, I've never heard the court use name, if considers him some sort of monster or evil, it's easy. It's easy for everybody on the camera, everybody who writes this, everybody who reads about it, to other Mr. Miu, to think of him as somebody so different than themselves that this case, this sentence, these actions don't apply to me as a human being. And that's the danger. That actually undermines what Your Honor is trying to do if Your Honor is thinking about the future and whatever happens here has some sort of influence on the public. Mr. Miu is a good man. He was in this situation and he's been convicted of doing a crime. And that doesn't diminish the consequences of his actions. But to talk about it in a way in which we other the person who does that, I think doesn't recognize the reality of all of our vulnerabilities out in this world. All of us in different situations. And all of our also responsibilities to do what we can in different situations to either prevent and or de-escalate violence. This was not something done by a monster. This was something done because of some circumstances that lots of people played a role in. And Mr. Miu, at the end of the day, is here to be accountable for his role in that. And circling somewhat back to just the accountability, right, Judge, and seriousness of the case, as well as remorse. There's, as Your Honor may be familiar with, there's a author in America by the name of Michelle Alexander. She wrote a book about the criminal justice system back in 2010. She's also occasionally writes in the New York Times an opinion, right? And I just want to quote some of an article that she wrote back in 2009. Survivors are right to question incarceration as a strategy for violence reduction. Violence is driven by shame, exposure to violence, isolation, and an inability to meet one's economic needs, all of which are core features of imprisonment. Perhaps most importantly, according to Ms. Sarid, that's a different author that she's quoting, that wrote a book called Until We Reckon. According to Ms. Sarid, quote, nearly everyone who has committed violence first survived it. And studies indicate that experienced violence is the greater predictor of committing it. Caging and isolating a person who's already been damaged by violence is hardly a recipe for positive transformation. She goes on to say, in many ways, when she talks about accountability, and this is where I want to circle back to remorse and Mr. Miu's being, through the system, isolated and not able to have contact necessarily with what we call restorative justice programs while the case is going on. Quote, our criminal injustice system lets people off the hook as they are not obligated to answer the victim's questions, listen to them, honor their pain, express genuine remorse, or do what they can to repair the harm that they've done. They're not required to take those steps to heal themselves or address their own trauma, so they're less likely to harm others in the future. The only thing prison requires is that people stay in their cages and somehow endure the isolation and violence of captivity. Prison deprives everyone concerned, victims and those who have caused harm, as well as impacted families and community, deprives them of the opportunity to heal, honor their own humanity, and break cycles of violence that have destroyed far too many lives. I quote from that, Judge, because while I recognize this is a prison case, the amount of prison is clearly in debate. It's clearly something that Your Honor is going to decide. And how do we break these cycles? And somewhat is a cycle of mindset of somebody gets harmed and they react and respond to that harm. And we're here to judge Mr. Miu for that reaction that he had in this setting that he did not set up. So what do we do as trained professionals who've had 732 days to contemplate what's the right response in a safe setting? I can't imagine a more difficult task. And I know I've heard Your Honor, if not other judges, say that sentencing is the most difficult task. But it's that measured response that I think we are required to give. In talking about the circumstances of the case, Judge, I do want to address just 4 points about the circumstance of the case, right? One of the things, is that's been talked about in the PSI, as well as in statements today, as well as in arguments today, is, walk away. I understand that, and I appreciate that. And I'm not trying to excuse, I'm trying to offer something that Gallion talks about is an ability to explain and articulate to Your Honor, so Your Honor might have a better understanding. And so I think the public can have a better understanding about what it is that created this situation. We know through the video that there was, Mr. Miu was walking away when some of the group of football players called him raper. And we know he responded to that. And I appreciate that the state's position is he should not have responded. He should have kept walking away. And I'm not trying to explicitly say disagree with that, but I'm trying to get so Your Honor might understand why a human being might respond to that. I think that those name calling, whether it's raper, whether it's pedophile, those are different than calling somebody a name that's specific to that person, right? That's just about not what they've done, but about their moral character. We've all heard the names, whether they start with an A or a B or a D or whatever it is. We've heard those names that I think lots of human beings have heard and they've walked away. When you're called something that says you have violated society's norms that I think we would all agree, everybody in this courtroom, that it's just, it's horrific, right? To be a raper, to be a pedophile who is preying upon somebody who's vulnerable. To be called that and to walk away might be seen as tacit agreement, right? Tacit agreement into those behaviors. And so I'm not saying everybody would, I'm not saying anybody should, but I can understand why somebody who's pro-social, who believes in community norms, might say, look, you can't call me that. You can't call other people that. You're breaking some norms about what you're saying, and I have to stand up to that to say, that's not okay. Not just the name calling, but that behavior that you accuse me of. It's not about the person, it's about those social norms. And that's something that I think you can't walk away with because you can't really say who cares. Somebody addresses you in that way, I think to walk away is to say who cares. And you know what? I do care. I would hope lots of people care. Lots of people would care if young, vulnerable people, children are sexually assaulted, women are raped. We should care. And a response to that kind of comment, I think, is, at its core, an expression of caring about that. That's why he turned around. It's not bad character. It wasn't an intent to harm. Then we come to the point where they talk about he should have walked away. And I get it. The 1 minute and 42 seconds into the video, he's standing, he's got the knife in his hand, there's 2 women in front of him, and there's other people that we can't see. I understand eventually we need to get to that 1 minute and 42 seconds into the video. But prior to that, the uncontested facts are he walks away twice. He did walk away. He walked away down the river to away from the group of football players that were tubing. And then he walked across the river to go over and talk to the other group of adults. He did walk away twice. Appreciate that the state's position is he should have walked away a third time. I understand that. But to say he didn't walk away, I think is inaccurate. And I think the record needs to show Mr. Miu always deserves to be sentenced upon an accurate record. He, in that situation, when he walked to the second time, as we've all seen in the video, he used his words. And it was shut down, and from then on, everybody has said he didn't use his words. That's what the state said. That's what some of the people who spoke today is he didn't use his words. I understand and appreciate that. As somebody who makes their living using my words, I appreciate the value in words. As somebody who listens to courts use words to solve problems, I appreciate the value in words. That's what he could be judged on, because he didn't use words. Why didn't he? We don't know. I think he said he was overwhelmed. He was afraid. He didn't know what to say. Could it be part of the language barrier? Could it have been other things? I don't know. But I think we need to put a pin in that. Use your words. What did he do then? As the state say, at the 1 minute and 42 second, he had a tool with him. We know he had a tool. It was a knife. And he opened up that tool and had it in his hand at 1:42. As the state said, he should have de-escalated it by showing the knife. I think that's worth mentioning, because I think it's a tacit agreement, at least from a moral standpoint, if not just a legal standpoint and a factual standpoint, a moral standpoint, that that circumstance was perhaps worthy of a person showing a weapon. He didn't, but I think that's, to understand the circumstances, I think that's essentially even if we disagree with it, we might understand why somebody in that position would take out their tool, right? He had a tool, and at the end of the day, he had a tool that nobody else had. He had a tool that nobody else had, and the manner in which he used that tool is why he's here. And I think the state's position is he used that tool harshly, right? But, and I think this is the last point on the circumstances of this, but it's an undisputed fact. And he deserves to be sentenced on accurate facts. He did not use that tool until violence had been done to him. Should he have used the tool? The jury said no, right? But I think in judging his actions and judging his character, that is something that I think is you have to consider. He did not use that until it was used upon him. The appreciation obviously goes towards the PSI as well, right? The appreciation of the wrongfulness. And I say that because, as Your Honor knows, I'm not telling you anything, that there's an executive branch. The executive branch is represented by the District Attorney's Office, represented today by Mr. Anderson and Mr. Smeestad. Mr. Anderson spoke. That's the executive branch. As often happens in a judicial setting, the judge, as you did here, asks other parties of the executive branch to make a report. In this case, it was the Department of Corrections. They made out a report. One of my position, what I submit to Your Honor is, there's a reason we put judges in charge of this and not the executive branch. Do not, I would submit to you, I would encourage you, try to persuade you, don't abdicate your authority to the executive branch. Don't abdicate your authority to a non-lawyer who doesn't have the same duties that a judge does. We all know judges have different duties. Gallion spells them out. There's all kinds of other things that I know I couldn't even list about the duties that a judge has that are different than a DOC agent, right? They're not bound by the law. They're not bound by Gallion. They're not bound by a process of reasoning. They're not bound by a logical rationale. And I say that because I'm going to submit here as an exhibit
Yes, we'll have it marked as exhibit number 1 in a moment.
Probably 2. I think the state had exhibit number 1.
2?
Thank you.
Exhibit
2. Your Honor probably knows, I hope, if not, for everybody to know, is the Department of Corrections has what we call a grid, right? They have sentencing recommendations for what should be recommended in the PSI for different cases. And it's a 9-box grid. You know, on the left is whether somebody's low risk, medium risk, or high risk. And across the top is whether the matter is mitigated, neutral, or aggravated. I'm going to use the term guidelines. They're not legal guidelines, all right? But it's certainly something that the DOC has. There's no mention of this anywhere within the PSI. Zero mention of this anywhere within the PSI. Nor is there any number on this grid that is consistent with the numbers that were submitted by the PSI. For lack of a better term, they went off the grid. Absolutely went off the grid. In the recommendations to the Department of Corrections as to how to use that grid, right? There's different things about assessing the severity of offenses and whether or not something can be mitigated, neutral, or aggravated. And all of the guidelines talk about how if they're going to claim something is aggravated, they need to list the reasons why. Not quite as strong as Gallion to talk about a process of reasoning, or a rational, logical basis, but it does talk about that. And the Department of Corrections in no way justifies how they got to aggravated, if they did. I submit to you that this is mitigated. It's mitigated because it's reckless. It's mitigated because of the circumstances surrounding this that were not all of Mr. Miu's doing. And if you look at that box, if you look at the box where it says it's mitigated and it's lower risk, as Your Honor said, that's a blue box. And the blue box says no presumption of prison or probation. It's based on the circumstances. The number inside that box says 1 to 2 years. Very different numbers than what the PSI recommended, very different numbers than what the state recommended. But that's a process of reasoning. That's a rational, logical way to get to something. They, by they I mean the Department of Corrections, didn't follow their own rules and didn't explain it. The interesting thing for me in Gallion, when it talks about it needs to be an explainable sentence, it needs to be an explainable sentence. You need to be able to articulate it. And I don't know if this is my common experience with that, Judge, is I've been at times, despite perhaps my verbosity today and in other times, I can't always explain things. There's been times when I've had a conversation with my wife, who's, as you know, smarter than me, wiser than me, more thoughtful than me in so many ways. And we're talking about something and she'll be like, well, articulate the reasons why. Explain it to me. She'll even set me up sometimes where she'll give me time. And I can't. I can't. Whether it's dealing with our children, whether it's something else in the household, and she'll come back and be like, yeah, you can't because that's an intuition, because that's an emotion, and appreciate all of that. But at the end of the day, that's not how we, I think as human beings, if we're mature and developed, should be making decisions. And it's clearly not what Gallion says we should be doing. We need to be able to articulate it and explain it. And if you can't articulate it, if you can't explain it, that essentially means it's because it's not rational, it's not following a process of reasoning. And I say that because all too often, and I can't recall, I don't mean to project onto Your Honor if I've heard it from Your Honor, but all too often I've heard that there needs to be punishment. And I appreciate that. I appreciate the value of punishment, but punishment is not an objective in and of itself. Punishment on its own is not worthy. We don't want anyone in the world to punish other people without some sort of future objective. Punishment is a tool. It's a tool that we use to shape the future. But punishment can't justify itself. And so when I've been in court, again, no disrespect to Your Honor, I don't think I've heard it from Your Honor, but when I've been in court and I've heard judges say, well, there just needs to be punishment, that is contrary to Gallion. That is something that they can't explain. That is something that they can't articulate. Punishment in and of itself is not an end. Punishment is a means. And we know prison is punishment, right? We absolutely know that prison is punishment. And that punishment, like I said, is not an objective. Punishment, if it's given, has to have a purpose.
And because of the circumstances in this case, whatever that purpose is, I think it cannot, should not be vengeance. As I wrap up here, Judge, some of the things I want to tell you just are, we don't have the death penalty in the state of Wisconsin. But there are death penalty cases across the United States of America, in America. And in those death penalty cases, in general, we ask the jury to do a duty, right? And what the jury is used, the jury's duty in that sense is to give, quote, a reasoned moral response to the evidence about the offense and the offender. A reasoned moral response. A reasoned moral response is not vengeance. Apologize. So circling back to I would encourage Your Honor, don't abdicate your authority to the executive branch. The executive branch and the judicial branch are very different. In many ways, maybe this is an oversimplification, but when I think of the executive branch, I think they speak about, that's who we are. This is my community. I live in St. Croix County. I've lived here for 28 years. And this is my government. And Mr. Anderson speaks for my government. He speaks for who we are in this moment. I get that. I might disagree with him, but it's different for the judge. I think judges in the judicial branch, right? Judges speak about who we ought to be. Not who we are, but to speak to everybody here about who we ought to be, right? There's a quote, if you will indulge me, that I have hanging in my office, painted on a wall. It's something that my wife gave to me. We have it in our home. Right? It's a quote from a German philosopher from, I think, the 17th century, Goethe. I have come to the frightening conclusion that I am the decisive element. It is my personal approach that creates the climate. It is my daily mood that makes the weather. I possess tremendous power to make life miserable or joyous. I can be a tool of torture or an instrument of inspiration. I can humiliate or humor, hurt or heal. In all situations, it is my response that decides whether a crisis is escalated or de-escalated, and a person is humanized or dehumanized. If we treat people as they are, we make them worse. If we treat people as they ought to be, we help them to become what they are capable of becoming. Now that's an incredibly profound quote, and I hope all of us at some point attempt to do that. We can't follow through all the time. That's an incredibly difficult task, especially here today, I have no doubt, Judge. But when we think of the judicial branch, we, not just Your Honor, the position, right? This is me as somebody who's been a participant, who went to law, who thinks of the law, the duty of the law. Judges, the judicial branch. We don't just want people who are smart. We want people with wisdom. We don't just want people who are thoughtful. I think we think of the judicial branch as someplace where there is measured. Not just analytical, but an understanding. Right? And I've seen Your Honor. Your Honor has shown wisdom, shown measured responses, shown understanding of other human beings. And I appreciate that today it's an incredibly difficult task that Your Honor has. But let me end with this. Your Honor is the only one here with a tool that nobody else has. Your Honor has the power to send another human being to be in a cage, to be in prison. we ask that whatever Your Honor decides today, that you are measured, you use your wisdom, that you are understanding, and that you perhaps craft a sentence that gives the community what they want, but also here under Galleon allows Mr. Miu the opportunity to get back out and live some period of his life, some time in which he can perhaps do some of the things of accountability that we talk about that I think are going to be more meaningful than a number. So, in the end, Judge, I appreciate that you have the tool of prison. Please use your words, not the tool.
Mr. Miu, this is your opportunity to make a statement, or, if you wish, to offer any reason why I should not impose a sentence today. Would you like to make a statement?
Judge, he's written out a statement to me. I had it in hand. I printed it just for easier. I think he wants to read it, and then I'll submit it to the court, so it's just a part of the record.
Certainly. Mr. Miu.
Do you want to stand? Okay.
Yeah.
Read it to the court.
All right. Dear parents, family, and friends of Isaac, I would like to start by letting you know how deeply sorrowed I am, and I will always be, for the real fact that Isaac is not with you anymore, and that I was directly involved in his very tragic and unimaginable death at such an early age. I never meant for this tragedy to occur. My soul is broken. My heart is very heavy. And I will never be the same carrying such a heavy burden and sorrow. I pray to God for forgiveness, compassion, and love for everyone affected directly and indirectly by the outcome of this tragic event. I'm hoping that you appreciate how much I'm sorry for the outcome of those events. I'm very sorry.
So we'll have that marked as Exhibit 3, Judge.
That'll be received into the record.
That's all then from the defense, Judge.
Mr. Miu appears today in court for sentencing. Count 1 is first-degree reckless homicide, which is a Class B felony. With the dangerous weapon enhancer, the maximum possible penalty is 45 years of incarceration, initial confinement, and 20 years of extended supervision. On counts 2 through 5, Mr. Miu appears for sentencing on first-degree reckless endangerment, Class F felonies with the dangerous weapon enhancer. The maximum possible penalties are 12.5 years initial confinement and 5 years of extended supervision. Last, count 6 is battery. That is a misdemeanor. With the dangerous weapon enhancer, he faces a maximum possible sentence of 15 months. In preparation for today's sentencing, I reviewed a number of materials. First, I reviewed the pre-sentence investigation report prepared by the Department of Corrections. It's a 43-page report that provided me with information that I knew and information that I did not know about Mr. Miu, about his victims, families, about Mr. Miu's background, about all aspects of this case, many of which were talked about today. That PSI report also included a sentencing recommendation. I also reviewed Mr. Nelson's sentencing memorandum. It too was very helpful. It provided more information about Mr. Miu and his background, and I valued that information. Mr. Nelson submitted numerous letters from Mr. Miu's personal friends and coworkers. I read all of those. I also read the relevant portions of the file, including the complaint, the jury instructions, and the verdict. In a moment, I will pronounce a sentence that I believe is just and fair. When deciding on a sentence, I must consider the gravity of the offense, including the effect on the victims. I must consider Mr. Miu's character and his rehabilitative needs. I must consider the need to protect the public. The sentence must be based on the facts of the case and the law, not personal considerations, passions, or prejudices. But judges in Wisconsin have a great deal of discretion when imposing a sentence. Unlike many jurisdictions, we do not have sentencing guidelines or grids to follow. I want all of you to know that I have given this case a great deal of thought. I take my responsibility seriously. There is nothing more difficult or more solemn than imposing a sentence on another human being. As far as the gravity of the offense, the jury has spoken. Any efforts to relitigate this case are simply without merit. I firmly believe that the American criminal justice system is the best ever devised. It's not perfect, but I cannot think of a system of justice that is better at finding the truth while preserving the rights of the accused. In this case, 12 jurors reached a unanimous verdict. These 12 jurors were selected from a panel of more than 150 people. I, along with the attorneys for both sides, chose these jurors because they could be fair and impartial. The jurors came from all corners of our great county. They came from all walks of life. They were men, they were women, they were young, they were old. They listened to 8 days of intense trial testimony. They examined dozens of exhibits. They deliberated for 8 hours. In the end, they reached a unanimous verdict and found beyond a reasonable doubt that Mr. Miu was guilty of reckless homicide, reckless endangerment, and battery. Now, there are 2 key takeaways from this jury's verdict that I want to mention. First, the jury rejected the state's claim that Mr. Miu intended to kill Isaac Schuman or the surviving stabbing victims. In other words, the jury rejected the most serious crimes that would have sent Mr. Miu to prison for the rest of his life. Second, the jury rejected Mr. Miu's claims of self-defense. That means Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or he did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This jury found Mr. Miu guilty of reckless homicide and 4 counts of reckless endangerment. These crimes are serious. They mean that Mr. Miu did not think about the consequences of his behavior and that he showed utter disregard for life when he stabbed 5 people. For that, he will be held accountable, but the court sentence must reflect the reality that it was reckless conduct that the jury found him guilty of, not intentional conduct, which is punishable much more harshly. In weighing the gravity of the offense, I consider the impact these crimes have had on the victims. The battery to Madison Coen was unjustified. While she did not suffer any permanent physical injuries, she has mentally suffered over this entire ordeal. She described to the PSI author the toll this case has taken and continues to take on her. This offense has devastated Isaac Schuman's parents and stepfather. No parent should have to endure the loss of a child. They have had to cope with the senseless death of a loved one while enduring the weight of the criminal justice system that can be slow, confusing, and sometimes frustrating to victims. To you and to your family, there are probably no words that I can say today that will alleviate your grief. But I would be remiss for not expressing my sincere condolences to all of you. I am sorry for your loss and what you've had to endure. Although it must have been difficult, I appreciate each of you speaking today and sharing a glimpse into Isaac's life and who he was. It sounds like he was a wonderful person, bright young man who had an unlimited future. And for that, we in this community have lost. A.J. Martin and Ryhley Mattison would have died on that riverbank had it not been for the swift action of law enforcement and EMTs and other tubers who helped to treat their wounds and stabilize their condition. They had long hospital stays, but they were very fortunate to receive high-quality medical treatment that restored their health. But we heard from them about the toll this matter has taken on their health, their mental psyche, and their prospects for the future. Anthony Carlson and Dante Carlson's wounds were less severe, but the risk to life was still present, obviously because the knife was directed into their torso near vital organs. But they fortunately have survived. Each of these surviving stabbing victims suffered permanent physical disfigurement, and that can't be overlooked. And we've heard from A.J. Martin just about how that disfigurement can affect one's life. In assessing Mr. Miu's character, I must consider his conduct on July 30. Mr. Miu's crimes were the product of circumstance, not intent. Mr. Miu was not looking to cause trouble or hurt anyone, but he made a series of very poor decisions. When confronted with words and boorish taunts and insults, Mr. Miu drew a knife and he struck Madison Coen. That quickly culminated in senseless, lethal violence. He left the scene, leaving his victims to die, while casually floating past them and emergency workers as if nothing had happened. He nearly reached his car. He nearly escaped the jurisdiction before law enforcement arrested him. These are terrible acts that form an indelible stain on his character. There is more to Mr. Miu than his worst acts. I can tell Mr. Miu has taken this case very seriously. He has been appropriate and respectful in his demeanor in court. I sense that he carries a heavy burden too. I imagine he is disheartened at the prospect of prison and the uncertainty of his future. But I also sense that Mr. Miu feels genuine sadness and remorse for what happened to his victims. I agree with the comments earlier that our criminal justice system is not designed in a way to allow people to apologize or to alleviate grief or to show respect to victims until a day like today at sentencing. That is unfortunate, but I heard Mr. Miu's words, both today and before, and I think he is sorry. Other than his conduct on July 30, Mr. Miu appears to be a quiet, nonviolent, peaceful man. He's never been in trouble before. He is loved by his family and friends. He's generous with his time. He helps others who are less fortunate or who are in need. Mr. Miu is respected in his community. Several of his personal friends and coworkers submitted letters that describe his character. Those letters were not shared in court today, but some of the most common words they use to describe Mr. Miu are kind, compassionate, friendly, loyal, respectful, and honest. Mr. Miu had to overcome great obstacles in life to achieve his place. He and his family suffered at the brutal hands of the communist regime in Romania. When he was a teenager, he and his family fled. They found asylum in the United States. Here he adjusted to a new country, new language, new culture. He got good grades in high school. He went on to college in South Dakota. He became an engineer. He worked hard. He had a successful career. I read somewhere in my materials that the proudest moment in Mr. Miu's life was becoming an American citizen. Mr. Miu has no rehabilitative needs. That means he doesn't need rehabilitation. He has no past criminal history. He does not associate with criminals. He has never used illegal drugs. He is not an alcoholic. He has not been diagnosed with a mental health condition, although there is evidence that he's experienced PTSD from July 30 while in the jail. Mr. Miu is educated. He has vocational skills. He has life skills. He's financially secure. He has a stable home. He has positive social supports. He knows the difference between right and wrong. He doesn't need rehabilitation. I mention all of these things to acknowledge that there is a lot more to Mr. Miu than what he did on July 30. I mention these things to recognize that a fair and just sentence takes into account the complete person, not just his worst acts at his lowest moment. Despite the seriousness of Mr. Miu's crimes, the evidence does not show that he poses an imminent risk to the public. Mr. Miu underwent a compass assessment, which is an actuarial tool that measures a person's risk of committing future crimes. Not surprisingly, Mr. Miu scored low risk. He's not a career criminal. He's not a violent predator. Although Mr. Miu may not pose an imminent risk to the public does have a strong interest in holding people accountable who breach the social compact and commit crimes. It's the concept of punishment. Punishment is a sentencing objective. When a person commits a serious crime, that person forfeits rights enjoyed by the law-abiding community. The most restrictive punishments are reserved for those who commit the most serious crimes. The punishment exacts a toll on the offender because of the harm the offender caused to the victim and the community. Taking life and endangering the lives of others are two crimes that warrant significant punishment. Punishment for what Mr. Miu did, but also punishment that recognizes who he is and the circumstances of his crimes. Here, that punishment will involve the loss of liberty, because anything else would depreciate the seriousness of his crimes. So at this time, I will impose the following sentence on Mr. Miu. For count 1, I will impose a term of initial confinement of 20 years, followed by 6 years of extended supervision. For count 2, involving Anthony Carlson, 5 years initial confinement, followed by 5 years of extended supervision. Count 3, involving Dante Carlson, 5 years of initial confinement, followed by 5 years of extended supervision. Count 4, Alexander Martin, 6 years of initial confinement, followed by 5 years of extended supervision. Count 5, Ryhley Mattison, 5 years initial confinement, followed by 5 years of extended supervision. Count 6, Madison Coen, 270 days of jail. Mr. Miu is not eligible for challenge incarceration program or the earned release program due to his age and the nature of these offenses. The sentences on all 6 counts will run concurrent. I am imposing a concurrent sentence because Mr. Miu's conduct toward each of his victims was part of a single continuous act over a short period of time. The periods of confinement take into consideration Mr. Miu's entire behavior, not just the behavior directed at any one particular individual. The conditions of extended supervision will include the following: maintain absolute sobriety, no possession of drugs or alcohol. You shall not enter any establishment where the primary purpose is the sale of alcohol. This will include places like bars, taverns, liquor stores, beer tents, and the like. You must complete an AODA assessment. You must comply with all recommendations of the Compass Assessment and the Department of Corrections. He must pay court costs and DNA surcharge on each count. He must submit a DNA sample. He may not have any contact with Isaac Schuman's family, including Elena and Danya Hernandez and Scott Schuman. He may not have contact with Alexander Martin, Ryhley Mattison, Anthony Carlson, Dante Carlson, or Madison Coen. He is responsible for restitution. The state must submit its restitution demand within 30 days. The defense may have 30 days thereafter to object. If there is an objection, the matter will be scheduled for a restitution hearing. Because Mr. Miu is convicted of serious felonies, he may not possess firearms. He may not possess body armor. He may not vote or hold public office until his civil rights are restored. If he were to do any of those things contrary to law, he would subject himself to additional criminal penalties. If he violates the no contact orders, he may also subject himself to additional criminal penalties. Does the state agree on the credit calculation, 732 days?
Yes.
All right, 732 days credit. Mr. Miu is remanded to the custody of the sheriff for delivery to the Dodge Reception Center. Is there anything else for today, Mr. Anderson?
No.
Mr. Nelson?
No, Judge.
All right. Thank you all. We stand adjourned.
And welcome back to our Fox 9 Streaming Center. I am Paul Bloom. Of course, that puts a close to the Apple River stabbing case that we have followed now for 2 straight years. Some stunning developments at the end. Yeah. When we think about, we talked about all morning, the discretion Wisconsin judges have, the potential maximum Nicolae Miu faced. We were talking upwards of 100 years behind bars, whether he would sentence consecutively for each of the victims injured, hurt, killed that day, or whether the judge would package us all up into one basic act and put all the victims together into a concurrent package. And that is what we got. So where it nets out, and I know it's not just numbers here, but a lot of people pay attention, and Judge Michael Waterman just sent Nicolae Miu to prison for 20 years. Correct. Start unpacking that for us.
There's a lot to unpack there. So, we had discussed the maximums, and then there was the 5-year enhancement that was added as well that the judge referenced when discussing what Mr. Miu could be facing here. Ultimately, the judge decided that these sentences were going to run concurrently. And that was the most shocking, in my opinion, of decisions, because although the judge imposed a sentence in prison for each of the counts, with the exception of the misdemeanor, of course, he decided that they would run together, which means that in terms of the time that Mr. Miu will be in prison, it will be 20 years less the 732 days of credit that he has. So he'll be out at around age 73.
Yeah, and important to note, because the way Wisconsin stacks their sentencing, there is a quote-unquote prison commit term, and then he put the extended supervision on. In Minnesota, we get the sentence where that quote-unquote 2/3 is baked in. Right. So very important to say right now, we can say definitively 20 years. I mean, this judge is well-reasoned. I'm not going to take a position on what he just did. I just thought he was very eloquent. I had asked you early on, would we get kind of a full accounting of what he did? And he clearly did that. And what's interesting to me, as we take a look outside the courtroom, this is Hudson, Wisconsin. We are on the ground outside the St. Croix County Courthouse. I would have to imagine reaction will be mixed. People will be all over the place. We know in that courtroom was Nicolae Miu's brother, who we see leaving right there. We know Miu had several supporters, different family members in there, and obviously Isaac Schuman had plenty of supporters there, and A.J. Martin, one of the ones badly stabbed, nearly died, as the judge recounted there, and he gave a victim impact statement today. What was interesting to me in terms of packaging up that sentence concurrently, meaning all together, was he even made he went 1 year higher for Martin, because Martin was most significantly injured. He imposed a 6-year sentence for that stab injury, as opposed to 5 for the other 3 who were lesser hurt. So the judge had some discretion in there, recognized that that was a more serious offense, but then still packaged it up into the concurrent. I don't know what we make of it. It's obviously his call. Wisconsin judges have huge discretion. That's what we saw just there.
Yeah, and I think here the judge really focused on the fact that this was not intentional. The jury specifically found that this was not an intentional act. And so the judge spoke about that and really focused on that. And then he talked about the reason that he's doing it concurrently is because he viewed it as a single continuous act over a short period of time. So this isn't a situation where Mr. Miu injured some, walked away, and came back and injured others. Based upon what the judge stated, had those been the facts, I think he would have then sentenced it consecutively instead of concurrently. But here he took into consideration Mr. Miu's history, his character as he outlined, and felt that it was appropriate to impose that concurrent sentence.
And one thing I thought was, he talked about, obviously, he was not convicted on first-degree intentional homicide, which he was originally charged with. That intentional crime comes with it in Wisconsin, a mandatory life sentence. So he made a point to say the jury did not convict on that level. And when you think life sentence, I think you can even take a step and say Miu's current age is 54. You know, we were kind of guessing maybe we would end up somewhere with that 75-year mark in terms of when he gets out at his age of 75, and that is where it netted out. So it's this, you know, who knows what happens with his health and his situation in prison, but at this point he is giving him a window, opening a window for Miu to potentially get out of prison. That would be an age of 75, a little short of that. But
yeah, as you and I heard the judge talking about the life sentence and how he is not looking at that because of the intent, you and I had talked about, we think he's going to be out right around there when you look at the average life expectancy of an American these days. So once the judge started making those statements, it was a flag to he didn't intend on imposing a sentence that guaranteed that Mr. Miu would die in prison.
Defense, what did I want to say about the defense there? They built up his character. You know, he shouldn't be judged completely for 30 seconds. But they did ask, Aaron Nelson did not put a specific number on the table, but he did open the door like probation could work here. You have a guy who, no prior criminal record, doesn't need treatment in prison. He's not going to do something like this again. I don't know, was that, did that hit with this judge, or how did you view, you said he could ask for probation.
Yep.
Seemed
not surprising, and he really focused on the standards and had talked about that when considering sentencing, the judge is to start at a position of probation. And so certainly he has to make that argument, but you also heard at the end, he didn't bang the table with it. He didn't ask the judge for a specific number of years in prison either. He really tried to focus on the judge and the judge's analysis of the factors that he's to consider and avoiding vengeance. You heard him talk about justice and that it doesn't involve vengeance over and over again. And so, I think it was a strategic call on behalf of Attorney Nelson, and I think it was a good call there because he didn't throw out a number, so the judge didn't look like, hey, I'm going closer to what the defense was asking for versus the state.
put yourself on that legal team, a defendant. Are you? I mean, no winners. No one feels good today, but are you breathing a sigh of relief? I mean, this could have been a death sentence in essence for him today, correct?
Right. This was a just sentence, as Mr. Nelson had said, and I think everyone on the defense team, including Mr. Miu at this point, are exhaling at the moment because now they know. Now they're going to start looking at potential appellate issues and moving forward with that. But Mr. Miu right now knows, here's my number, here's my age. And so both he and his family are exhaling, and hopefully, again, although not what they were seeking, hopefully the victims' families and the victims themselves have some closure because now this phase of the court proceeding is done.
Yeah, your attention has to turn to the victim's family, and we know, although we couldn't show it to you this morning because we were barred by the court, by Judge Waterman, who again, you don't necessarily agree with all of his decisions. He seemed well-reasoned. You could imagine the impact on these families to pour out their hearts in victim impact statements. We understand, there were clearly tears. There was anger in that courtroom. Family members referring to Miu as an evil monster. We weren't able to show those victim impact statements to you because of a judge's order that said the victim impacts would be off camera. We know A.J. Martin gutted, by the knife that day, died, was needed to be resuscitated. Basically was dead for 9 minutes, he said in court today. He was in the gallery. He stuck around for that sentencing. But you do wonder how this falls on them because, let's be honest, if you do look at the max, and by no means does our system say someone deserves the max every time, but Miu was looking at 90 some odd years in prison if you said this was the worst crime and he deserves it. So 20, no matter how you cut it, they're going to be, if not angry, disappointed in just purely the number.
Absolutely. And again, there's no number that's going to bring Isaac back. There's no number that's going to take away the pain felt by the other victims. But we heard the judge talk about his reasoning why he imposed that. And something that we also saw, I hope everyone had caught this, but when Attorney Nelson was telling the story about release of Isaac's body, the camera had zoomed in on Mr. Miu, and I think that's very important and very powerful because at that moment, we saw some real emotion from him. He's been called a monster, he's been called a demon, but you saw at that point that he was affected. And that's not something that was practiced, that's not something that was staged. You could tell at that moment that story was true, it was real, and it had an impact on Mr. Miu hearing about that process and the fact that Isaac's body hadn't been released yet.
And may have helped counter some of the stuff the state had mentioned about jailhouse phone calls recorded with Miu and apparently his brother in a native language. So there was some debate over translation, but really some harsh, ugly language, verbiage used, early on in jailhouse phone calls about the young boys, you know, at the heart of the encounter on the river that day. Isaac Schuman, Jawan Cockfield, who shot the video, and others, some harsh language. So there was some ugliness painted about Miu's character, and then you did, you know, see some humanity in that moment. And I had heard that anecdote before about the release of the body, but again, important to note for our viewers that it was a homicide investigation, autopsies, medical examiner. The defense has the opportunity perhaps to put an expert in the room to be part of testing, and Miu clearly had said early on that no, let the family go ahead with their funeral arrangements and plan the next steps there. We are keeping an eye on a camera outside the courthouse right now. We expect members of Isaac Schuman's family, at least his stepdad, did stop outside the courthouse after the verdict. Donnie Hernandez, who's in the courtroom next to Isaac's mom. There's a chance we hear from them just to see if they want to share their sentiments. My guess right now, perhaps meeting with Carl Anderson and the state team to kind of process what they just heard and how to digest that. Again, it's been 2 years. You know, they were throwing around terms like evil monster, demanding the max. Again, the max 90 plus, and in the end, the prison sentence ended at 20. There's A.J. Martin right there leaving the courthouse under some security watch there. He's obviously peeling away from the camera, so we won't hear directly from A.J. Martin, but how it's impacted his life. We understand during his victim impact statement, he talked about obviously the psychology of what happened, the having to be resuscitated, the post-traumatic stress that he lives with, but also the human toll of the wound, the scarring, every time he takes off his shirt to go swimming, to shower, whatever, it would always be a reminder there. There's a part of me that wants to take a moment right now. Obviously, we'll keep an eye on the courthouse exit, but we edited up the Nicolae Miu's statement today. We weren't sure if he was going to speak, just the way he just seemed blank today. His head was bowed for a lot of it. He didn't seem like he was checking on notes to maybe prepare for a critical statement, but he did end up speaking to Judge Waterman. It was just about a minute. I think it's a good time, Ryan, to play that right now as we keep an eye on the exit, and as soon as somebody comes up to the microphone, we can always cut in if needed. But let's take a look back. This is not too long ago now, but Nicolae Miu in court speaking to Judge Waterman.
Dear parents, family, and friends of Isaac, I would like to start by letting you know how deeply sorrowed I am, and I will always be, for the real fact that Isaac is not with you anymore, and that I was directly involved in his very tragic and unimaginable death at such an early age. I never meant for this tragedy to occur. My soul is broken. My heart is very heavy. And I will never be the same carrying such a heavy burden and sorrow. I pray to God for forgiveness, compassion, and love for everyone affected directly and indirectly by the outcome of this tragic event. I'm hoping that you appreciate how much I'm sorry for the outcome of those events. I'm very sorry.
Nicolae Miu apologizing there. Just in first blush through the camera seemed human and real and from the heart, if you will. Spoke for about a minute there right before Judge Waterman sentenced to him. And then breaking news, as you see on our banner there, 20 years total as you kind of do these sentences because they run concurrent. 20 years basically on the top count, which is the first-degree reckless homicide of Isaac Schuman. That's where the 20 years comes from. He did tack on subsequent amounts, 6 years A.J. Martin, 5 years Dante Carlson, 5 years Tony Carlson, 5 years Ryhley Mattison, and then a little less than a year in the local jail confinement for the Madison Coen battery. But again, all of that time gets condensed into 20 years. Debbie Lang, local criminal defense attorney, Hallberg Criminal Defense, has been with us all morning. We so appreciate you being here. Just wondering, as you assess his apology, what did you make of it?
Well, it was very short, And as you may have noticed, he didn't make any statements to the other victims. He focused on Isaac. Additionally, in the beginning, you may have heard his attorney whisper to him and say to address the court with his comments, because initially when he stood up, he turned to address the family. And that is appropriate. It is to be addressed to the court. However, you still saw at the end when he stated his final apology of "I'm sorry," he again turned back to the family. And so again, that's not something his attorney told him to do. I think that does show that he wanted to make that statement directly to Isaac's family.
And here is Aaron Nelson, Nicolae Miu's defense attorney. He's not shy about coming up to a microphone. Let's hear what he has to say.
Understand, right? Obviously, we were hoping for a sentence that gave him a more realistic opportunity of coming back out. But I guess those are my thoughts.
And just to clarify, in Wisconsin, 20 years means 20 years. There's not an
Correct. There's, I believe, 3 programs. One is earned release program he's not eligible for. One is child incarceration program he's not eligible for. There's another program that I probably should know more about, and I don't, that wouldn't take place until 75% of the sentence is served. So it wouldn't, and even then, if he'd even be eligible, it's a petition that the state, the Schuman family, the court, lots of other people have input on.
That's a significant downward departure. So, I mean, what is it you think that had the biggest impact when it came to that fact?
The number that the judge gave? I mean, he used his words and explained it. I mean, it sounded like he was saying, the fact that the jury spoke and said it's not intentional, that it was reckless, is certainly something that he took into consideration in deciding what do we need to, how do we shape a sentence that's going to reflect that. The rest of Mr. Miu's life, some of what I like to think is something he already believed, not something I said, but just this was the worst moment, but there's a lot more to Mr. Miu that we could judge, and you have to take all of that into consideration.
Aaron, because these are being served concurrently, this means he would be released when he's 74.
He'll be released 20 years from July 30th, 2022, so I think he would be 72. He was born in 70.
Because of the 2 years count.
So the 20 years started July 30th of 2022.
Does Wisconsin give credit then for that date that he's already served?
Yes, the sentence starts July 30th of 2022, or today minus 732 days.
And then the number of years on the sentence.
Correct.
Years from now, when you look back on this case, what do you think you'll remember?
What do I think I'm going to remember? I don't know how that's relevant. I mean, my own personal experience about it is, probably like most of my cases, if I was going to look back and remember something, it would be like, what if I did this? What if I did this? If only I'd have said this. Maybe I could have better explained this. Maybe I should have made this other argument. I mean, not necessarily regrets, but, we obviously have our beliefs. I understand the system. We're members of the system, and I appreciate and respect all the decisions that were made within the system, but at the end of the day, we stand by our positions we've said in court, both before the verdict and after.
Did you have a chance to speak with Mr. Miu after the sentencing?
Yes.
And what are his thoughts, his demeanor? Did he say anything? Was he surprised, not surprised?
What I'm happy to share is, his demeanor is, I think, as the judge articulated up on there, he's carrying a heavy burden for lots of different reasons, and this is something that he takes very seriously. And he's still processing how he's going to deal with all of that.
Was he surprised by the sentence, or no?
I'm not going to share that.
It was kind of hard not to notice how much weight that he has lost, and in my opinion, even since the trial. Is he doing okay health-wise, or is there anything you could share on that?
I think that there's nothing that I can share other than stress and diet, right? I mean, this is not meant to be a criticism of the St. Croix County Jail by any means. It's just jail by its nature is going to be not the place where people flourish, right? And so whether it be their health, their mental
health, their physical health. It's not a place for flourishing. And I think what we've seen is he's suffering.
Is there any appeal process going forward there?
I imagine that he's going to file a notice of intent to seek post-conviction relief. That's going to be a lengthy process. That'll be in the hands of some other attorneys. Undoubtedly, they will have to look at, our performance, my performance, and see if there's anything along those lines or what the courts do. But that's for another day and other lawyers. All right?
Thank you.
Thank you.
Thanks.
It's Attorney Aaron Nelson wrapping up his portion of the case. Just your quick reaction to what he just said at the microphone.
Nothing unexpected that came from him. He obviously can't share the conversations that he just had with his client, So, nothing out of the norm here. I mean, he was respectful to the court, addressed the questions bluntly and as he could, but
respectful of the media might have asked not the greatest question too in there, but clearly, there has to be some relief that number came down where it did. I know, he speaks eloquently and respects the process and certainly reaches out to the victim's family, specifically Isaac Schuman, but everybody involved in this. But they are grateful today that Judge Waterman had a reasoned approach, took some of the stuff that Aaron Nelson had, not saying it was a direct regurgitation of what Aaron had said about his client and sort of how you define Nicolae Miu over a lifetime, but clearly Judge Waterman took some into account. And again, the headline here, of course, is 20 years in prison, all served concurrently.
Given the exposure, Aaron Nelson has to be pleased with that outcome. He's obviously not pleased with the outcome of the jury, the guilty conviction. However, given the exposure that his client had, this was a good outcome for his client.
90 plus years, as I've kind of been saying throughout, upwards of 100 years in prison was the maximum potential if he had done maximum charges and then served consecutively. Here it goes concurrent. So Nicolae Miu, who spent 2 years already in jail in Hudson, you heard one reporter ask about his health. He does appear to have lost a lot of weight over those 2 years. Gaunt, they would say he's lost a lot of color. Obviously, you heard Aaron Nelson there say it's not a place to flourish, but wouldn't otherwise address his health. But now he heads off to prison. 20 years. He gets credit for the 2 years he's done in custody. He was never able to post bail, which is interesting. Obviously, I believe that the number was $1 million, and I think in Wisconsin, you have to come up with that in full cash. There's no 10%. So he was never able to make bail. Clearly, he put some money into the defense team. Those are two powerful Wisconsin attorneys that were hired for him. But then after the conviction in April, the judge revoked his bail. So there was no possibility even at that point then that he would get out. So he's been in jail. He gets credit for 2 years. You heard Aaron Nelson say there he could be out of prison around 72 years old, given that he's now 54 years old. I'm just trying to keep an eye on the courthouse camera. It's unclear who else might speak. It's possible Carl Anderson, the district attorney, comes out. I have been told at different points where we've been cutting in and out that Isaac's family appeared to walk by without wanting to say anything.
Understandable.
Yeah, we saw A.J. Martin walk by under a little bit of security. Obviously, they're not just our camera there, but there's other media, so they wanted to get the deputy with him. As he headed home, he gave a victim impact statement. I'm curious what their thoughts are, if there's anger, frustration today. Obviously, it's just an emotional day for so many. Many of them, including A.J. and the family, had given intense victim impact statements by all accounts, so we were not able to bring that to you because of judge's orders. But as we wrap this up, I guess that we should probably get to that phase. I mean, where are you on this case? I mean, is it, I don't know, we felt like at the time, at the conviction when I was sitting with your colleague Marsh Hallberg, that reckless seemed to be the right conviction point in this case, not intentional, not acquittal, maybe not total self-defense, that reckless seemed right. Now today we get sort of what you described as a just sentence. Is that how you walk away from this?
Yeah, I think, when looking at the evidence, I think most individuals had indicated that the intentional verdict would have been a surprise. And so the question really focused on if the jury was going to believe it was self-defense or not. And here ultimately they found that self-defense did not equate to the defense, which would result in a not guilty verdict or an acquittal. And so they found that his conduct was reckless. Here, I think looking at Mr. Miu's history, looking at this snapshot in time in terms of what happened here, that less than 2 minutes of decisions that were made and actions that were made, the judge felt that 20 years was sufficient for this individual. And you know, again, I think that makes some sense.
Yeah. And what do you think about this case makes it so interesting, kind of even beyond our region? Obviously, for us, the Apple River, it's a tubing. I mean, I know there's a magnet to draw partying and revelry and young people. And, you know, if people who have used it said there's often, you might run into a fight, certainly nothing like this. But, you know, where it happened, you know, the cell phone video, him on tape lying, like, blatantly. Is that what the circumstances, cameras in Wisconsin courtrooms, is that what you think has kind of generated this to a different level of just sort of your everyday, you know, maybe claims of self-defense, you know, that put this on a higher level in terms of media and community interest?
Yeah, I think all of those factors play into it. And I think this is a case as well that a lot of people think, well, what would I have done? What would I have done differently?
Well, let's take a break here, Debbie. I think this is his brother,
really glad that this process
Isaac Schuman's brother.
I remember getting the call from my other son. It was the worst phone call I ever received. And I feel that justice has been served. I'll keep my opinion on the sentence to myself, but I'm really glad that this process is over. I really want to move forward, and the rest of my family wants to as well, and spend the rest of my life honoring my son. And that's all I got.
There was a lot of talk about whether he was remorseful or not. Do you believe that he is remorseful? Did you believe his apology?
I'll say that I'm happy that he did apologize. I still need to process that. But I didn't expect it, and I was happy that he did that.
Scott, could you talk about how you would like your son remembered?
Well, I think the foundation that his mother started was a great idea, because Isaac was an entrepreneur himself, and just from the turnout at different events early on, there was hundreds of people. He touched a lot of lives. He was an amazing kid and had a bright future. So, yeah.
Scott, was the family expecting closer to the 70 years that the prosecution was asking for? Or just a sense of what the expectations were today? We don't really know that.
I can't speak for his mother because I don't know, but I was expecting maybe double what he got. So I'm a little surprised at that, but I'm glad that I don't have to be the judge and make that decision. Either way, I'm ready to move forward, and I'll let the rest of it play out. So, thank you very much, everybody. Okay? All right, have a good day.
So that is Scott Schuman. That is the father. He has not necessarily been a familiar face, been on the sort of the periphery of the family. Obviously, a loving dad there. He's certainly someone I know has followed the case closely. I'm not sure if he'd been there every day at the trial. We've certainly gotten to know Isaac's mom and her new husband, Donnie Hernandez, who you know, raised the two boys, Jacob, and then of course Isaac Schuman, Elena's husband, Donnie Hernandez. But that is Scott Schuman. That is Isaac's dad. He clearly stopping at the podium there that the media has set up outside the St. Croix County Courthouse in Hudson, Wisconsin. You know, I will point out he seems ready to move on. He will honor and love his son forever. He did expect double, meaning 40 years at least, in terms of prison. So again, the number does matter to these people who've gone through hell, and there will be no bringing back, no number will bring back their son, but he did say there that he expected double the amount of time.
Yeah, and he also indicated that justice had been served. Yeah. And so I think what he's referencing there is the fact that Mr. Miu was convicted and that the jury spoke and they didn't believe self-defense. And I think that's a really important component for Isaac's family, is that Isaac didn't deserve this. Yeah. And so the fact that there was that conviction, I think, is what he's referencing when he says justice has been served.
I'll take one last look at the camera outside the courthouse. I don't see anybody else coming, not saying they won't. We have Karen Scullin on the ground for Fox 9 News, so we can be rest assured Karen will be wrapping up today's events at the courthouse. Perhaps gotten some feedback from Mom, Elena Hernandez, Donnie Hernandez, Jacob. We obviously saw Jacob Schuman. A lot of Isaac family members were in that courtroom today for today's news. And again, the headline here today, 20 years in prison. You see it on the bullet on your screen there, the headline, sentenced to 20 years in the Apple River stabbing. There are some additional numbers, but for all intents and purposes, all of the sentences get packaged together concurrently. 20 years behind bars. He gets just about 2 years, because this incident happened July 30th, 2022, almost 2 years to the day. He gets credit, Nicolae Miu does, for all of the time he's already done. So 2 years basically comes off those 20 years. This is Debbie Lang, Hallberg Criminal Defense. Debbie, thank you so much for walking us through sentencing today. We so appreciate your time and your input. It was wonderful analysis. And we thank you for watching. But for now, it's 11:44 Central. We'll wish everybody a good rest of their day. And thank you for joining our Fox 9 coverage of the Apple River stabbing case.